Good morning, Suraj, Faridabad, NCR Bharat, and Jai Bharat. Good morning, Bharat, 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 my Bharat. We, people of this country, Bharat, India, having solemnly resolved to constitute ourselves into sovereign, socialist, secular, democratic republic, nation to secure to citizens justice, liberty, and equality, whatever else, so that we can create brotherhood, fraternity, and dignity of individuals in this nation, which is nation, a great one, headed by Bharat Mata, land of Bharat, and land of ours, we people of this country. And Vande Matram again, and Satyemev Jyete, no one can defeat truth. This is set principle. Truth cannot be defeated. It cannot be disregarded. It has to stand even against the trillion, millennial false statements, millennial fake news, and whatever. One truth is always heavier than whole world fake statements, fake words, fake information. This we have to understand very well. We are not just a society of individuals, but society of 140 crore people with soul and mind and bodies, with all problems for resolution which are pending. We have to take that into ourselves. Very ancient country, Bharat, unknown start, unknown date of birth, unknown initiation, but moving gradually, smoothly, persistently, without any major worries, because we were called golden sparrow in those days. Golden sparrow means we are not made of gold, but we were very rich people, had no problems from eating viewpoint, from feeding viewpoint, and from living viewpoint. But we have lost that level because of many reasons, not one reason. Our whole culture has changed according to world is changing, and we have changed. Keeping apart all those issues and just weaving in currently identity of ours, status of ours, we have to think once again to set our direction that has been deflected somewhere, diverted somewhere by some people who have no aims of life for themselves and for this nation, Bharat. We have to review that, we have to audit that and set it right and correct if any error has been caused. That is sole purpose of our talks, our contemplation, our dissemination of whatever we contemplate, and sharing knowledge with all people of Bharat. We got independence from our cruel leaders, or you can say them owners, masters, British, who ruled us for many decades. They never wanted to leave us. They wanted to stay here forever. But it is people who are owner of this land to decide whether they have to allow intruders to stay here, who came as guests forever they have to stay, or they have to decide themselves whether to retake ownership, whether to pull back ownership as we have today, which started back in 1947, and before that, for 100 more years, these rulers suppressed and oppressors, our people, applied all kinds of cruel formula onto us. And before that, other rural stays here for centuries, many centuries. And before that, others. Aryans or those who call Eurasians, they ruled us. They disputed us. They fought with our original people of this country. They threw them off from current positions. We have to learn lessons from those times. And if we don't learn lessons from those times, this means we act like owls and donkeys. And those animals who don't use mind only live to eat food with no quality of life. We people in this country in 2019 are not that level. Of course, we ignored ourselves, we ignored our status, we ignored our responsibilities, but we were sleeping because reason was that. Now we have to awaken ourselves. We have to rise to occasion. We have to rise to current circumstances that are conflicting in ourselves. It's a conflict. Multi-directional conflict, multi-dimensional conflict. This conflict must be understood and analyzed, and then for each answer we have to find another answer. That is what we have to do. No political relation, we are talking for society. It's a part of society I am and you are. I'm not linked to any political party and I don't want to be. And I am sure you are also talking as a citizen of this country, which citizenship has been challenged now. Everybody is citizen and there is no need to prove it again. And they are only befooling people of this country to prove again that you are citizen. Those people who are elected by citizens, they are asking their masters, their honors, their clients to prove that you are citizen. Ridiculous it is, ridiculous. Really. Nonsense. A stupid idea. My one question to all of them is very open and dire question and widened question. You were elected by whom? You were elected by people of this country, and those people, who they are? Those people are citizens of this country. If these citizens elected you, you are asking them, you're challenging them, prove your citizenship. What do you mean? This means either you are fool or people are fool. Either you are over smart or people are over smart. One has to be over smart. We have to compare that. Best thing is, because those who elected you, you are challenging them, you are asking them to prove they are citizens. This means initially now, according to your contemplation or concentration, they are not citizens. And if they are not citizens, you are not required to demand votes from them. This means whatever votes you got to win elections, those votes were by non-citizens. Therefore, it is your moral duty to leave these positions of MPs and go away from your offices, because you are elected by fake citizens, and then citizens would decide what they have to do. You, all MPs and PM and POI, you're all linked to fake votes, fake citizens. So you leave these positions and go away. It is people of this country. They have to decide whether they are fake or they are genuine. And they will decide themselves. You are no way, in no power, have any right to decide about them. You are just their representatives. And if you don't like this, you leave your position and stay as you were, a common citizen. That's it. This is advice to you. This is public demand to you, whatever you consider. And then Independence of India Act 1947. Independence of India Act 1940. Yes, we are talking about. We're talking about that 2 days back. We have to understand that. And before that, We have to see in background what statute had ruled us since 1935. I'm not talking about statute that ruled us since 1919, because that was repealed. Statute under which we were ruled till our constitution was empowered and initiated and commissioned. That was Government of India Act 1935, about which I was deliberating, and I am sure you must have acknowledged or got some ideas from that. It's nothing new, only lapses that we people don't go to past to retrieve what we were. But without understanding what we were, we cannot claim what we are. We have to know our track back. We have to know what we were. Only then we can understand what we are. That is very important. Let me just speak a little one, same thing in Hindi. भारत के लोगों, हम भारत देश के नागरिक, हम भारत देश के लोग इस भारत को अपनी स्वच्छ निष्ठा से बनाते हैं। एक ऐसा देश जिसमें प्रभु सत्ता हो, जिसमें समाजवाद हो, जिसमें पंथ या धर्म निरपेक्षता हो, लोकतंत्र हो, गणतंत्र हो, और ऐसा देश जो इन सब पैमानों को लेके हुए सुरक्षा दे, गारंटी दे, न्याय की, बराबरी की, स्वतंत्रता की, और वो सब चीजें लेके जाए आगे हर नागरिक को। एक मान सम्मान की जिंदगी, एक भाईचारे की जिंदगी, एक सामाजिक न्याय की जिंदगी, एक सामाजिक समता की जिंदगी, ये हमारा संविधान हमें देता है। हमारा संविधान जो कि भारत की पूरी जनता ने मिलकर बनाया, उसको हमें मानना होगा और सल्यूट भी करना होगा भारत के नाम पे। जय भारत के नाम पे यह भारत का संविधान। और जो नहीं करेगा वो इस देश का एक सच्चा नागरिक नहीं हो सकता, वो कोई भी क्यों ना हो। पहले संविधान, फिर आपका धर्म। धर्म आपका अपना है और संविधान हम सबका है। ये फर्क को आपको समझना होगा, क्योंकि वहां बैठे हैं वी पीपल। वहां हिंदू नहीं बैठा, मुसलमान नहीं बैठा, सिख या ईसाई नहीं बैठा, पारसी या बौद्ध जैन नहीं बैठा, वहां बैठा है तो भारत का नागरिक बैठा है, वी पीपल। हम लोग वहां बैठे हैं। हम लोग को आप बेइज्जती नहीं कर सकते, हम लोग के साथ आप झगड़ा नहीं कर सकते। जो झगड़ा करेगा वो अपनी पावर से जाएगा, वो कितना भी ऊंचा क्यों ना हो। जो हम लोग का ध्यान नहीं रखेगा वो इस देश की शक्ति नहीं बन सकता, क्योंकि सर्वशक्ति इस देश की भारत की जनता, हम लोग हैं सबसे ऊपर, जिन्होंने इस देश का संविधान बनाया। संविधान में जो भी लिखा है, जो भी संस्थानों के नाम लिखे हैं, वो सब संस्थान हम भारत के लोग की ऑथरशिप में हैं, भारत के लोग की ऑनरशिप में हैं। वो चाहे फिर सुप्रीम कोर्ट हो, या वो लेजिस्लेचर हो, या वो एग्जीक्यूटिव हो, या कोई और भी क्यों ना हो, CAG हो, जो भी हो, आप सब भारत की जनता के अधीन आते हैं। इस बात को आप अच्छी तरह जानते हैं, हम मानते हैं ये बात। और अगर आप नहीं जानते, भूल गए हैं, तो हम आपको याद दिलाते हैं, आप कितने से बड़े क्यों ना हो, भारत की जनता आपसे बड़ी है। आप बेशक पार्लियामेंट क्यों ना हो, भारत की जनता आपके ऊपर है। आप बेशक न्यायालय क्यों ना हो, भारत की जनता आपके ऊपर है। और आप कोई भी शक्ति क्यों ना हो, भारत की जनता आपके ऊपर है। इस बात को मत भूलिएगा, उतना ही आपकी सेहत अच्छी रहेगी। भूलोगे तो आपको तनाव होगा, आप समझ नहीं पाएंगे, बेशक आपने कितनी भी पढ़ाई क्यों ना की हो। ये बात आप क्लियर रखिए, माइंड में रखिए कि भारत की जनता आपको पैसा देती है आपकी जिंदगी चलाने के लिए, और उसी पैसे से आप यहाँ रहते हैं। भारत की जनता आपको नहीं देगी तो आप ये कुछ नहीं कर पाएंगे। इसलिए भारत की जनता पहले है, आप बाद में आते हैं। पहले भारत आता है, बाद में धर्म आता है, बाद में कुछ और आता है। सब लोगों के लिए यही है। कोई ये नहीं कह सकता मैं पहले हिंदू हूँ बाद में भारतीय हूँ, या पहले मुसलमान हूँ बाद में भारतीय हूँ। जो ऐसा कहेगा वो अपने आप को ही दोषी कहेगा। खैर आगे चलते। भारत का संविधान हमारे पास है, वंदे मातरम भी हमारे पास है, तथा भारत का नियम कानून हमारे पास है, वो सब ठीक है, हमारा सब कुछ हो रहा है। लेकिन आज जो चल रहा है उसका बारे में बहुत जरूरी सोचना होता है। एक ऐसा आंदोलन खड़ा हो चुका है, बर्निंग आंदोलन, बर्निंग स्टेट कर रहा है, जब पब्लिक सड़कों पे आ जाती है। ऐसा पहली बार हुआ है, फर्स्ट टाइम इट हैज हैपेंड since 2014 when Modi came to power. People had trusted him, people had put their faith in him, but he has not proven positive, he has not proven that he is competent, he has not proven that he is capable to that faith which people expressed on him, people put in him. That faith has broken somewhere. लोग सो गए थे 2014 के बाद कि चलो एक सुपरमैन आ गया, एक सर्वशक्ति आ गई, देश को संभाल लेगी, सारी प्रॉब्लम को सॉल्व कर देगी। सोचा था लोगों ने ऐसा। People had a contemplation that this man has come to power and solved many problems because people therefore extended full trust in this person. But this person failed to prove that. People actually slept since 2014 to 2019. They slept and I was worried about that. If a society sleeps, people in power abuse them. And he abused. He abused. He abused in all terms. He abused from demonetization of high-profile notes, then GST, and then you can say economical problems. He sold companies, government companies, and then you can say abuse to J&K, and now abuse to secularism, abuse to constitution. He never did anything in support of public, in support of nation. So faith must have broken. People digested everything. In 2014, 15, 16, they digested all. They accepted all troubles. They can say they accepted every ill-sent means, all unemployment, they digested. They digested all hard life, all whatever given to public by demonetization of notes. And then J&K people digested all atrocities. They don't speak. People did not extend support to J&K people, unfortunately. They should have been supported by all society of other areas, but it didn't happen. And now when attack is done, attack is focused, attack is targeted on the common man by this government and parliament, people were shocked. It's not a question of migration of people, it's different question exclusively different. There's no issue on migration. Previously also citizenship was granted to many people from Pakistan and other nations. Nobody is questioning that. But question is inaction of parliament, silence by parliament, sleeping status of parliament. When parliament sleeps, people sleep. Parliament is considered legal house, highest legal house of this nation, constitutional house. If those people do not work properly, problems do come in, and that has come in. If parliament is meant only to pass bills, stupidly, we don't need such parliament. If parliament cannot analyze bills, parliament cannot brainstorm them. It is not a question of treasury benches or opposition benches. It's a question of right or wrong. It's a question of suitability or non-suitability. They are sitting there to check and examine and audit each and every act done. It's not a question of head count. It's a question of quality of bills which are converted to acts. That quality has missed somewhere, everywhere. Many bills have been passed without any debate, and if debates were conducted only for name's sake. We don't need such speakers, we don't need such chairmen, we don't need such ministry who cannot who cannot work according to constitutional requirements. If you are just to count heads in parliament, how many people are supporting, how many MPs not support, if that is only an idea criteria to devise and design and accept these or approve these bills, there's no meaning of debate. Why do you conduct debate then? What's the meaning of that debate? Why are you wasting time then? Why are we fooling ourselves? It's a question. If debate, which is very significant part of democracy, openness of democracy, vibration of democracy, if that debate is only for name's sake, whatever is coming out of that, output of that, if that is not considered to incorporate into whatever act or law you are going to make, if it's only for record purpose, it's only for publication of journals of parliament, there is no meaning of such debate to be conducted. Why to waste public time and your time? If you are MP, you must have competency to understand constitution. And if you cannot understand constitution, you have no right to sit in chair of MP. You are cheating nation, you are cheating yourself, or you are cheating public. You have no right to cheat public if you don't understand constitution. If you don't understand what's going on, hardly 50-60% will lie there. In every debate, not more than 50, 60, 70, 80 MPs are sitting there and debate is ongoing. What's the purpose of debate? You are not able even to participate in the debate. Public cannot participate because public cannot enter Lok Sabha, Rajya Sabha. But you are a competent person there representing people in the House of Delhi is the authorized representative. If you cannot do that, what's the function there? We should not pay you anything and just throw out from parliament in that case. Are you paying you for that? To miss debates? You have to talk. And it's not a question of shame, crying all time and thumping desk of parliament. We don't want that. We want quality and quality debate. We want your quality participation. We want your enthusiastic participation. We want to know facts. And it's not simply duty of a speaker just to say yay or no, ayes or no. No. We don't want to move lakir ke fakir. If debate is there, it has to tell world this has come out of and incorporate that. If just condemning all proposals from other parts, that is not called debate. That is just you are doing a formality in parliament to get this passed and that's all. Passing is no solution. It should be enriched. If bill is not enriched, there is no meaning of parliament. It's a post office. Is our parliament a post office? We have to consider that. If 50 speakers participate in debate and no suggestion is received or accepted, why do they waste time? And why do you waste their time? And why do you waste national time? If you have to force whatever is included in bill, that has to go. This is not debate. This is a stupidity. You have decided, it's prejudicial. You have decided that this has to go. Why do you conduct debate? What is the meaning left behind that? I want richness. I want enrichedness. I want to enrich my act, my bill, my law. But that is not enriched because you don't want to enrich this. And no meaning of parties or opposition parties because they're all negotiations conducted for bills. You are conducting negotiation for bills. Believe me, this is a crime. You are just withdrawing from bills. You are walking out. Be clear. Be open, either support openly or oppose openly in interest of people, in interest of nation, or else you're cheating yourself and cheating nation. If I'm not clear why bill was passed or reason behind that, what's the meaning of parliament? It's just no need of parliament in that case. You just approve yourself and that's it. Democracy is not functioning. If you have to do your way, what PM decides, what cabinet decides, that's final because you want to impose your intentions on public. Public do not need your intention to be imposed upon them. They need comfortable life, helpful life. We have to help this nation, not any political party. We are not servants to political party. Parliament is not meant for political parties. Parliament is meant for public. Public, all classes of public. And if you cannot deliver that, you cannot give that, then you are not working in national interest. Whoever you are, to whatever level you are just doing for your sake. You are just doing for the implementation of your agenda. That is not allowed. Constitution does not allow that. Mind it. And all parties mind it. Parties in treasury and parties in opposition, all mind it. People cannot accept everything that you want them accept. People have choice. People have constitution. People are understanding. People are reading. And when youth reads, be careful. Well, मैंने जो कहा, ये लोग जो हमारे चुनाव करके आए, हमारे वोटों से आए, सीटों पर बैठे हैं, ये सिटीजनशिप की बात कर रहे हैं, नागरिकता की। हम इस देश के नागरिक डाउटफुल है। अगर हम इस देश के नागरिक नहीं है तो भाई हमारे वोट क्यों लिए आपने? आपको हमारे वोट लेने की आवश्यकता क्या थी? पहले वोट ले लिया और अब कहते हैं अपनी नागरिकता का सबूत दो। नहीं देंगे। जो कर रहे हैं कर लो, जाओ। गोली चलानी है, बम चलाना है, जो करना है कर लीजिए। आप होते कौन है मांगने वाले? होते कौन है आप? औकात क्या आपकी? इलेक्टेड रिप्रेजेंटेटिव, बस इतना ही है। चुने हुए पदाधिकारी, चुने हुए एमपी। हमने चुना है आपको, देश की जनता ने चुना है। और उसी जनता से आप कह रहे हो कि सबूत दीजिए कि आप इस देश की जनता हो। अगर 100 में से 2-3 लोग बाहर से आके मल मिक्स हो गए तो उसको छाना जा सकता है। उसके लिए आप सबसे सबूत मांगेंगे? क्या अधिकार है आपको सबूत मांगने का? कहां संविधान में लिखा था ये करें? संविधान में नागरिकता साफ साफ लिखी है। आप उसको नहीं मानते? आप होते कौन है नहीं मानने वाले? क्या वो काफी नहीं थी? आप बाहर से लोगों को लाना चाहते हैं, लाइए। कौन रोक रहा है? आपके वोट बड़े हैं, हम जानते हैं, लाइए। लेकिन संविधान के हद में रहकर लाइए। अगर आप संविधान के ऊपर कूदेंगे, उसकी बाउंड्री से बाहर आने की कोशिश करेंगे तो आपके पैर हाथ कट जाएंगे अपने आप। संविधान की दीवारें ब्लास्ट रेजिस्टेंट भी हैं, इलेक्ट्रिकल करंट भी है उनमें, और उनमें तूफान भी है, उनमें ज्वालामुखी भी है। जो संविधान को टच करेगा, छेड़छाड़ करेगा, याद रख लेना उसका अंत बहुत बुरा होगा, वो कोई भी क्यों ना हो। संविधान को छेड़ने वाला ना बचा है ना बचेगा। इंदिरा जैसे नहीं बचे, आपकी क्या औकात है? उसने भी संविधान को छेड़छाड़ करने की कोशिश की थी तो देख लो कहां भेज दिया था पब्लिक ने उसको। और उस समय तो कुछ भी नहीं था, कोई कम्युनिकेशन नहीं था। आज तो कम्युनिकेशन की हद है। अगर आप नागरिकों को कहते हैं आप नागरिक नहीं थे तो भाई आप भी हमारे प्रतिनिधि नहीं थे। आपने सीट पर कैसे स्वीकार किया बैठना? इसलिए पहले तो अपनी सीटें छोड़ी है। आप सारे एमपी यहां से छोड़ के रिजाइन देके जाइए। जनता अपने आप फैसला कर लेगी आगे क्या करना है। क्योंकि हम तो आपके सिटीजन है नहीं। आप कह रहे हैं आप प्रूफ, हम नहीं देते प्रूफ। क्या करेंगे आप? हम प्रूफ नहीं देते, आप क्या कर देंगे? गोली मारेंगे, मारिए। जेल में डालेंगे, डालिए। नहीं देते प्रूफ। हम संविधान को मानते हैं, आपको नहीं। हमने आपको बनाया है, हमने संविधान बनाया है। हम संविधान के राइटर हैं, हम संविधान के मालिक हैं। हम संविधान के हिसाब से देश चला रहे हैं और आप भी उस संविधान के हिसाब से इस सीट पे बैठ के सरकार बना चुके हैं। तो ये सरकार भी जाली है, ये एमपी भी जाली हैं और राष्ट्रपति भी जाली है, प्रधानमंत्री भी जाली है। क्योंकि आपको भारत के फ्रॉड नागरिकों ने बनाया है, जो नागरिक है नहीं, क्योंकि सबूत नहीं दे पाए। मेरा पासपोर्ट भी जाली है जिसमें लिखा है आप भारत के सिटीजन हैं। कहते हैं ये पासपोर्ट भी नहीं प्रूव करता कि आप सिटीजन है। चलिए माना आधार प्रूव नहीं करता, इस बात को हम स्वीकार करते हैं, क्योंकि आधार नागरिकता नहीं देता। आधार एक रेजिडेंटशिप देता है कि आप इस देश के रेजिडेंट हैं। वोटर कार्ड क्या कहता है? वोटर कार्ड जो वोट का हक देता है, मत देने का हक देता है, मताधिकार का हक देता है, वो क्या कहता है? वो कहता है आप 18 साल से ऊपर की एज वाले नागरिक हैं। आप उसको भी नहीं मान रहे। आपको पता ही नहीं क्या मानना है क्या नहीं मानना है। आप पासपोर्ट को भी नहीं मान रहे। मैं कितने देश घुमाया पासपोर्ट लेके, हर जगह पासपोर्ट में यही लिखा हुआ है भारत का सिटीजन। ये भारत का सिटीजन है, जाके भारत की एम्बेसी में या भारत की कमीशन में या भारत के वहां पर पोस्ट में रजिस्ट्रेशन करा लीजिए कि हम यहाँ हैं, वहां हम सिटीजन हैं। पासपोर्ट के अंदर वहां राष्ट्रपति द्वारा कहा गया है कि मेरे देश का यह आदमी बेरर है जो सिटीजन है, इसको हर तरह की सहायता दी जाए, कहीं रुकावट ना दी जाए। आप उसको भी नहीं मान रहे, तो वे आप क्या मानते हैं? हम मानते क्या है आपको भी पता नहीं आप क्या मानते हैं। भारत के सारे सिटीजन नहीं रहे, भारत के पासपोर्ट नहीं रहे, भारत के वोटर्स नहीं रहे, और कहने का मतलब यह है कि भारत नहीं रहा, भारत मोदीमय हो गया है, भारत शाहमय हो गया है। इसलिए आप सब गलत हो गए, वही सही है। दो आदमी जो इस देश को अपने हिसाब से चलाना चाहते हैं और उनको मालूम नहीं है कि देश चलाएंगे कैसे। उनको ना स्टीयरिंग संभालना आता है, ना क्लच गियर संभालना आता है, और जबकि गाड़ी ऑटो गियर है, उनको कुछ आता भी नहीं है, लेकिन सब कुछ करना चाहते हैं, सब कुछ तोड़ना चाहते हैं। तो हमें ऐसा आदमी नहीं चाहिए जो सब कुछ बने बनाए नक्शे को स्क्रैप कर दे। हमें ऐसा आदमी नहीं चाहिए। हमें चाहिए समझदार व्यक्ति जो बात को समझे, जो इंटेलिजेंट हो, जो ब्रेव भी हो, जो समझदार भी हो। हमें ऐसा आदमी चाहिए। ऐसे आदमी का हमको क्या कर रहे हैं जो बनी बनाई चीज को खराब कर दे। संविधान बनाया, इतनी मुश्किल से बनाया, कितनी रिसर्च करके बनाया, और उसको वो नाले में फेंकना चाहता है। क्या करेंगे ऐसे आदमी का? इसलिए हमें पहले समझना होगा, अच्छी तरह समझना होगा। बहुत से लोग जो कह रहे जी इस पर विरोध करने की आवश्यकता नहीं बिल पर। अरे पहले आप बिल तो समझ लीजिए, कानून समझ तो लीजिए बना क्या है। आप समझे नहीं है, बस बोले जा रहे हैं। कोई किसी का दुश्मन नहीं है यहाँ, बात को समझिए, संविधान को पढ़िए तो सही। संविधान क्या कहता है? संविधान किसी धर्म का गुलाम नहीं है, यहाँ की नागरिकता किसी धर्म से बंधी नहीं है, संविधान किसी धर्म से बंधा नहीं है। संविधान बिना धर्म का है, संविधान धर्म निरपेक्ष पंथ निरपेक्ष है, जिसमें धर्मों की वैल्यू है लेकिन धर्मों की मान्यता नहीं है। संविधान नहीं है हमारा जो धर्म की बात करता हो। हमारा संविधान पब्लिक की बात करता है, हमारा संविधान देश की बात करता है। धर्म की बात करने के आपका धर्म है, जैसा मर्जी मानिए, कोई रुकावट नहीं है उसमें। संविधान साफ साफ कहता है आप किसी भी फेथ को प्रोफेस कीजिए, कोई रुकावट नहीं है, जब तक कि दूसरे को नुकसान ना हो, दूसरे को उसका खमियाजा ना भुगतना पड़े। तो पहले आप समझ लीजिए, कोई नहीं कह रहा कि आप बाहर से मुस्लिम को आने दें या ना आने दें, कोई नहीं कह रहा कि इसको आने दें। ये भ्रम फैलाया जा रहा है। आपने संविधान के इस कानून में, इस नियम में जो बनाया है, इसमें आपने गलत भाषा का प्रयोग किया है, बिल्कुल गलत भाषा, जो संविधान जिसकी परमिशन नहीं देता। इसलिए कहा जा रहा है कि ये एंटी कॉन्स्टिट्यूशनल नियम बना है। आपको आवश्यकता नहीं थी ये कहने की कि कौन कौन धर्म आएगा। आप साफ लिखिए, जो भी परेशान होंगे, जिसको भी सही समझा जाएगा कि ये परेशान है, वो इस देश में स्वागत है, ये लिखना चाहिए था आपको। बात खत्म थी। और फिर आपने खास तौर से 3 देशों के नाम लिखे हैं। किस खुशी में भाई? ये 3 देश क्यों? आप सब लिखिए जो भी हमारे आसपास के देश हैं, वो कोई भी देश क्या ना हो, जहां पर अगर कोई अन्याय हो रहा है किसी के साथ, हम उसकी सहायता करने के लिए तैयार हैं। सिंपल सी बात थी। आपने एक डिजाइन के अंदर जानबूझ के ऐसे शब्दों का प्रयोग किया है जो कि बेसिकली फंडामेंटली गलत है। मतलब ये आप डिसाइड करेंगे अब इस संविधान में क्या होना चाहिए, नहीं होना चाहिए। क्या कचहरी कोर्ट कहती है, हम उसकी बात नहीं करना चाहते, क्योंकि जजेस भी इसी देश की जनता से गए हैं ऊपर। जज कोई भगवान नहीं होता, और आप तो बिल्कुल भगवान नहीं है। गलती करें आप और उसका प्रॉब्लम भुगते पब्लिक। आप जिसको मर्जी आने दें। आपने पहले भी लोगों को नागरिकताएं दी हैं, कौन रोक रहा है आपको? इस नियम की तो आवश्यकता थी ही नहीं। ऑलरेडी हमारे पास सिटीजनशिप में लिखा है, एक्ट में और संविधान में लिखा है कि किस तरह से सिटीजनशिप दी जाती है। क्या वो काफी नहीं थे? आपको जान के कहेंगे कि नहीं थे, क्योंकि आप अपनी बात को, नाक को अपने को ऊंचा रखना चाहते हैं। पर सब जगह हमेशा अपना नहीं चलाया जा सकता। याद रख लेना, आपके इस काम ने, आपके इस एक्ट ने एक अच्छी बात तो जरूर की है कि पब्लिक की आंखों को खोल दिया है, पब्लिक को नींद से उठा दिया है, जो कि नहीं हो रहा था। ये एक अच्छी बात हुई है. Really good it is that public has come back from dreams. Public had been sleeping since 2014 and it has come back now. That is really against you and been pro in favor of Bharat. I was really concerned. People have been sleeping, young had been sleeping, old had been, all had been sleeping, having full trust in one person, that's called Modi. But now that has reversed. This upside down it is. It's inverted. Your status has inverted. Unfortunately, or fortunately, both. It's unfortunate it's for nation that there has been unrest, there has been turmoil in the whole nation. People are on road, youth are on road, seniors are on road, middles are on road. And remember, road is more powerful than parliament. Road is for public and parliament is not for public. Parliament is only for MPs and road is for public. Public is 140 crore and MPs are only 800. Remember, it is public that's honor. It's not MP that they are honors. They are public representatives, and representative means representative, that's all. No power. It's delegated power you have, but public is not having any delegated power. Public is having original constitutional power. Public is having constitutional power. It is citizen power. It is personal power, and you have to scare of that power. Maybe your prime minister, your home minister, your president doesn't make a difference when you compare it to public. Public is public. Remember, it is public of this country that's got liberation from UK, not your parliament, not you. Mind it. Mind it very well. Solve it sooner, it's better. Or you have to go from your seat of power and somebody else will come and work on this seat. That is what this constitution says, and it mandates you have to comply with duty of citizen, fundamental duty that constitution mandates. You yourself are asking people to do your duty. Are you doing your duty? Did you ask yourself? You never ask yourself. Did you ask people before enacting this bill what they did? You notify to people the draft of bill? You never did that. Did you give time to public for 1 month or 2 months to submit their suggestions? You did not do this. Why? When such important bill comes which impacts all public, it's not impacting only a section of society. It's not impacting a community. It impacts whole nation. It was your responsibility, your obligation to notify draft of public at least for 60 days or 30 days to seek their advice. Did you do that? You did not do that. You just brought it as if emergency has come and you have to decide this today. You didn't do that. Why? Is it not part of the procedure? You should have done that. That is your error, your mistake. So public, you have just boiled public. You are heated up public. Maybe public wrong, maybe you are wrong, who knows? Question is, you have attacked soul of constitution of this country. And those intellectuals, those authors on various posts on social media, those who do not have any knowledge, thorough knowledge or required knowledge from constitution of this country, first they read constitution, they understand what is required before writing any illogical post. It's not a question of people here. It's not a question who should come from Pakistan, from Bangladesh, from Pakistan. Question is, what is fact? What is justified? That's important. Nobody is against those people who may come. Nobody is against them. But We are against structure of language, structure of contents in that bill that is giving thumping treatment, that is giving applied heat to people. People are heated of something which is unbecoming included on that bill. That is what we have to understand. If students can understand, collegians can understand, they are educated people, people can understand why government cannot understand, why intellectuals who are just blindly supporting that bill or act cannot understand. That is my point. You think whatever you want to think, but you cannot think beyond Constitution. You cannot harm Constitution. No one has got any right to harm our Constitution, because our Constitution is our soul. Bharat is our Constitution. Preamble is our Constitution. Bharat Mata is our Constitution. And mind of people which produce this Constitution is only going to accept what is right. And those who cannot understand that, better do not disseminate false information. This is my advice to all people, because this is very delicate time. After, you can see, many decades, such revolution has come in, and this revolution comes from intellectual areas. This is called universities, and that is very powerful. And this revolution shall change this nation, and change so many things you cannot even imagine, because you are impacted upon education, you are impacted upon burning minds. Those minds have been sleeping for decades, you have burnt them. Remember, a student is a student. A student has open mind. A student has a power to raise questions. A student has a right to raise questions, and those students who raise questions certainly get answers, and that is called learning. So you have impacted your arrow onto those eyes of students, onto those minds of students, and that is what mistake you have caused. It's not blind public without minds. It's a student who is a learner. And learner cannot be defeated, remember. Learner cannot be defeated. Teacher may scold a student, but that is also learning. Teacher may punish a student, but that is also learning. Punishment is also learning. On equal pattern as appreciation is learning, as praise is learning. So remember, you have gone in astray direction. You have gone in wrong direction. You miscalculated your strength. People were with you till you are right. You are thinking for people, you are thinking for a nation. Even nation accepted all their wrongs. They accepted your bad acts. But now water has come about eyes and nose. Either you set yourself right, you retrieve, you go back what you have done, or you have to face public unrest. It is still unrest, yes. Rising hasn't come. Rising hasn't come. Do you want rising to come? Then you can see where you would stand. Public का बहुत हो गया. पब्लिक ने बहुत सहा, बहुत सोया, सालों साल सोई, और 2014 से तो सो ही रही थी. सो गए थे सपने लेते हुए कि कोई आ गया है, मसीहा बन गया है देश का, गंदे लोग चले गए हैं, चोर डकैत चले गए हैं, ये आया है, बहुत ईमानदार है, सत्यवादी के खानदान से है, देश का कल्याण कर ही देगा. ऐसा विश्वास जगा लिया लोगों ने और आराम से सो गए, अपनी दुनिया में लीन हो गए. लेकिन बीच में पेशाब आया, आंख खुली, जाके देखा तो परेशानी शुरू हो चुकी है और 6 साल हो चुके हैं. पब्लिक ने आपको दोबारा वही सीट पे बिठा दिया, चाहे वो ईवीएम की से बिठाया हो, सीट पे आप बैठ गए. और जब आपने देखा कि अब तो दूसरा आ गया है, पहला 5 साल पूरा हो गया है, अब अपना प्लान हम शुरू करते हैं, ये सब नहीं चलने वाला. आप कुछ भी सोचते रहें, संविधान है, उसको आप हाथ लगाएंगे तो याद रख लेना आपकी उंगलियां चलेंगी और देश चलेगा। उसको जितना आप छेड़ेंगे उतना देश चलेगा, उतनी आपकी उंगलियां जलेंगी। इसलिए ज्यादा विश्वास रखना भी कई बार गलत हो जाता है, इसलिए होश में आ जाओ। मैं सिर्फ इतना कहना चाहता हूँ आपसे, बातों की 100 बातों की एक बात, अगर आपको इस देश तो अपने ख्यालों से निकाल दो कि हम इसको चेंज करेंगे संविधान को, या हम चेंज कर देंगे। कोई विरोध में नहीं है कि बाहर से लोग आ रहे हैं तो आने दो, किसी को उस बात से फर्क नहीं पड़ेगा। लेकिन इस बात से अवश्य फर्क पड़ता है कि आप संविधान की जड़ों को हिलाना चाहते हैं, आप धर्म के नाम से संविधान को जोड़ना चाहते हैं, जो संभव नहीं है। हमारा संविधान धर्म से लिंक नहीं है और आप लिंक करना चाहते हैं किसी ना किसी रूप से, जो कि नहीं माना जा सकता। और जो लोग इस बात की सपोर्ट कर रहे हैं कि ये ठीक पास हुआ है बिल, उन लोगों को भी सोचना चाहिए। खाली किसी की बात को फॉलो करना ठीक नहीं है, उसकी बात की जड़ों में जाना चाहिए, नहीं तो आपका इंटेलिजेंट होने का कोई फायदा नहीं है। अगर आप इतनी बात भी नहीं समझ सकते कि पहले सोच तो लिया जाए सपोर्ट देने से पहले कि सही क्या है गलत क्या है। कोई विरोध में नहीं है इस बात के कि पाकिस्तान अफगानिस्तान से लोग आएंगे तो आने दो, पहले भी बहुत आए हुए हैं, बात वो नहीं है। उसके लिए नियम बहुत है, इसकी क्या आवश्यकता पड़ी थी? सवाल तो ये उठता है। जब संविधान हमारा धर्म डिफाइन नहीं कर रहा है, धर्म का नाम नहीं लिख रहा है, तो आपको कौन सी बीमारी हो गई थी कि आपने धर्म का नाम इसमें लिखना था? आप छोड़ देते धर्म का नाम लिखना, आप खाली कहते थे ठीक है सरकार देखेगी, मिनिस्ट्री देखेगी या जुडिशरी देखेगी कौन आया है, सही है या नहीं है, बात खत्म थी। उसमें फिर आप लेते या नहीं लेते वो आपके हाथ में था, लेकिन संविधान को उसकी अटैक तो नहीं होती। और कोई अगर कोई परेशान होता है इस बात से कि आप उसको आने नहीं दे रहे, तो उसका रास्ता कोर्ट था, वो कोर्ट में जा सकता था। लेकिन आपने कोर्ट को भी बांध दिया और आपने देश को भी बांध दिया, संविधान को भी बांध दिया। यह कहकर कि इस कम्युनिटी का आदमी नहीं आएगा या और दूसरे लोग इन कम्युनिटी के अलावा है वो नहीं आएंगे। यही आपने गलती की है। आवश्यकता नहीं थी पहले तो इसकी, चलो आप ले भी आए तो कम से कम संविधान की मर्यादाओं में रह के लाना चाहिए था, संविधान की बाउंड्रीज में रह के जाना था। लेकिन आपने तो बाउंड्रीज को कूदने की कोशिश की। अगर वहां स्कैडा लगा हुआ है या कुछ और लगा हुआ है, इलेक्ट्रिक करंट तारों में लगा हुआ है, तो करंट तो आपको लगेगा, चोट तो आपको लगेगी, उंगलियां आपकी जलेंगी और देश साथ में जलेगा। वो आपने जला दिया है, जल रहा है। जब सड़कों पर लोग आ जाते हैं, समझ लो कि सरकार खतरे में है, सरकार का अस्तित्व खतरे में है। सड़क के ऊपर लोग का होना मतलब जानते हैं, सड़क पार्लियामेंट तक भी जाती है। मतलब अगर सड़क नहीं तो आप पार्लियामेंट नहीं पहुंच सकते। मतलब ये कि सड़क पार्लियामेंट के ऊपर है, सड़कों पे लोग हैं तो आपकी कोई औकात नहीं। पार्लियामेंट में बैठ के अपना रौब जमा लें, अपनी पावर दिखा लें। पार्लियामेंट होती है, संसद होती है, लेकिन लोग संसद से ऊपर होते हैं, क्योंकि वो लोग हैं, वो जनता है, वो देश के नागरिक हैं, उन्होंने संविधान बनाया है। आप तो संविधान के नीचे बैठ के काम कर रहे हैं, और अगर आप गलत काम करेंगे तो जनता आपके ऊपर है, आपको चेक करने के लिए, आपको ठीक करने के लिए, और वो ठीक कर देती है फिर। और अगर यदि उसमें विद्यार्थी हो, पढ़े लिखे लोग हो, यूनिवर्सिटी वाले हों, तो फिर और भी प्रॉब्लम हो सकती है। आंदोलन विद्यार्थी जो करता है उसका फल अवश्य मिलता है, उसका फैसला अवश्य आता है, चाहे किसी भी रूप में आए। ये बहुत बड़ी बात है समझने के लिए आपकी। यहाँ पे लोग आपसे नौकरी नहीं मांग रहे हैं, यहाँ पे लोग दुकान खोलने के लिए नहीं मांग रहे हैं, वो तो अब आपसे मांगेंगे भी नहीं, क्योंकि आपने सब खराब कर दिया है। बात इकोनॉमी की नहीं है, बात इज्जत की है, संविधान की बात देश के मान की है कि हम किस दुनिया में रहेंगे, हमारा देश कैसे चलेगा। ये बात आपको अच्छी तरह समझ लेनी चाहिए। पब्लिक किसी की बंधी नहीं है, किसी की गुलाम नहीं है। होंगे आप किसी के गुलाम, आप आरएस के गुलाम हो सकते हैं, आप बीजेपी के गुलाम हो सकते हैं, आप कांग्रेस के गुलाम हो सकते हैं, सीपीआई के गुलाम हो सकते हैं। आप पब्लिक को मत मानिए कि पब्लिक किससे गुलाम है। पब्लिक में भी 10, 15, 20% लोग गुलाम हो सकते हैं, लेकिन 80-90% पब्लिक गुलाम नहीं है किसी की। भक्त होंगे बीजेपी के, कांग्रेस के, वो होंगे गुलाम उनके, लेकिन भारत का वोटर, भारत का नागरिक किसी का गुलाम नहीं है। वो अपनी सोच सकता है, हाँ, आपने कुछ समय के लिए उनको सुला दिया था, लेकिन अब आपने उठा भी दिया और एक तरह से अच्छा किया। भारत का युवा कम से कम आज की तारीख में, मुझे खुशी है जानकर कि कम से कम कॉन्स्टिट्यूशन को समझ रहा है, जो वो 70-72 साल तक नहीं समझा था। देश का देश का देश की जनता आज समझ तो रही है, कोशिश तो कर रही है कि भारत का संविधान आखिर है किस चिड़िया का नाम। आज उन्हें समझ आ रहा है, शायद जो अभी तक नहीं आया था। 1947-50 से आज तक नहीं समझ आया था कि संविधान एक्चुअली क्या है। आजादी है, डेमोक्रेसी, सब समझ आया, डेमोक्रेसी सबको समझ आई, लेकिन बाकी चीजें समझ नहीं आई। वो 2019 के दिसंबर का मैं धन्यवाद देना चाहता हूं कि आपने जाते जाते 2019 ने जाते जाते अपना ड्यूटी पूरा कर दिया देश की तरफ कि देखो देश के लोगों, गलत थे आप, समझ लो संविधान क्या होता है। संविधान समझना लोगों ने शुरू कर दिया है, और जब लोग संविधान शुरू कर चुके हैं तो फिर सरकार की खैर नहीं। सरकार अपनी नहीं चला सकती और न्यायालय भी अपना नहीं चला सकता, क्योंकि सबको संविधान की बात को पढ़ के मानना पड़ेगा, और नहीं तो सीट पे बैठने का हक वो खो देते हैं, कोई भी क्यों ना हो इस देश में। संविधान संविधान है, संविधान देश की आत्मा है, संविधान देश का धर्म है, संविधान देश की जनता है, संविधान देश है, संविधान जिंदगी है, संविधान गलत काम से मुक्ति है, संविधान धर्म को दूर करता है, संविधान देश को एक करता है, संविधान देश में भाईचारा बढ़ाता है, संविधान देश में न्याय बढ़ाता है, बराबरी बढ़ाता है, मान सम्मान बढ़ाता है, अधिकार बढ़ाता है। संविधान का मतलब यही है। विधानों का विधान है संविधान, हजारों नियम अधिनियम होंगे, लेकिन संविधान एक है। जिसने इस संविधान को तोड़ने की कोशिश करेगा वो अपने हाथ पैर नाक कान कुटवाएगा, वो कोई भी क्यों ना हो। बड़े बड़े आए और चले गए, बड़े बड़े मानते थे हम पता नहीं क्या कर देंगे, अंत में पिटना ही पड़ा उनको। और जो आज हैं वो भी पिटने के लिए तैयार रहे, नहीं तो चुपचाप अपनी गलती मान लें और जो गलत किया उसको सुधार लें। नहीं तो जब पब्लिक जागती है तो फिर पब्लिक होती है, सबकी माँ बाप होती है, देश की मालिक होती है, और बाकी सारे के सारे संस्थानें देखती रह जाती हैं। आप गोली चलवा सकते हैं, आप लोगों की पिटाई कर सकते हैं, आप लोगों को घर तुलवा सकते हैं, आप सब कुछ कर सकते हैं, लेकिन आप पब्लिक को चेंज नहीं कर सकते। जितना आप लोगों को मारेंगे पीटेंगे, याद रख लेना लोग उतना ही मजबूत होंगे, उतना ही आगे चलेंगे, क्योंकि ये एक लड़ाई बन चुकी है, एक ऐसी लड़ाई जिसमें संविधान को बचाना है, देश की मान सम्मान को बचाना है, देश के स्ट्रक्चर को बचाना है। एक समय आ गया है, एक ऐसा समय जो किसी ने कल्पना भी नहीं की होगी कि हमारे देश में ऐसा भी हो सकता है। आप जितना मर्जी इंटरनेट बंद करा लेना, जितना मर्जी बंद करा लेना, लेकिन जब लोगों की दिलों में कोई बात पहुंच जाती है तो उसका फिर आंसर आपके पास नहीं होता है, और आज वही हो रहा है। मैं तारीफ नहीं कर रहा बच्चों की या किसी की भी, लेकिन एक बात जरूर हो गई है कि वो समझने लगे हैं, क्योंकि आखिर हैं कौन हम कौन हैं, who we are, what is meaning of we people. These people have started understanding, and that is really a great achievement by the CAA, which has initiated explosive state of public in this country. Public is exploding, and there's no meaning those who are coming to support that they are on roads. If you are supporting something, why you are on roads? What meaning is there? There's no meaning of counting quality. You are just saying, oh, you are here to oppose this and we are here to support it. No meaning. You support it, fine, you support it. Because you are unaware, you are ill-informed, you are never analyzed for what you are supporting. You are not analyzed. You did not use your mind. Better use it first. Well, I'll go to what I was talking yesterday about. I was discussing about, you can say, first of all, this was Government of India Act which we were discussing yesterday. 1935, and let me see. Yes. Government of India Act 1935, we were talking about yesterday. I had taken many provisions of that, and which was I just repeat about in index of that one, which generally in any act. This act is of course repealed in 1950 when Constitution came to power. Yet we must know back of that, otherwise it won't be able. Though it's a very long document, so I was just explaining yesterday. Let me see what titles are there. The first one is this is in section one is short title, then Government of India by Crown, then Governor General of India and His Majesty, Representative Secretary, and then Commander in Chief in India. And then, of course, it is Section 5, Proclamation of Federation of India, the annexation of Indian states, and then 7 is Functions of Governor General, and Section 8 is Extent of Executive Authority of Federation, then you can say Section 9, Council of Ministers, other provisions as to ministers, then Section 11, provision as to defense, ecclesiastical affairs, external affairs, and tribal areas in Section 12, special responsibility of Governor General, provisions of instrument of instruction, superintendence of Secretary of State, financial advisor to Governor General, Advocate General for Federation, conduct of business in federal government. Then Section 18 is Constitution of Federal Legislature, sessions of legislature, propagation and resolution, right of Governor General to address and send messages to chambers, then rights of ministers, councillors, and advocate general, respects chambers and officers of chambers and voting of chambers, power of chambers to act notwithstanding vacancies and quorum, then Section 24, oath of members and vacation of seats and disqualification for members and penalty for sitting and voting when not qualified or when disqualified, privilege and of numbers and salaries and allowance of members, which is 29, and then Section 30 is the provision of provision as to introduction and passing of bills and joint sessions of both chambers in certain cases and assent to bills and powers of Crown to dissolve acts. And then Section 33, annual financial statements, procedures, legislature with respect to estimates, authentication of schedules and authorized expenditure and supplementary statements of expenditure and special provisions as to financial bills. And then Section 38, rules of procedures English to be used in federal legislature, restrictions of discussion on legislature, courts not to inquire into proceedings of legislature. And then Section 42 is power of Governor General to promulgate an ordinance during the decision of legislature, power of Governor General to promulgate ordinances at any time with respect to certain subjects, power of Governor General in certain circumstances to enact acts, and then Section 45, power of Governor General to issue proclamations. Then come on to other one. 46 is governors of provinces, 47 is the provinces and the bearers, and then it is 48, appointment of governors, 49, executive authority of province, and the council of ministers, 50, Section 15, other provisions as to ministers, special responsibility of governor, provisions as to instrument of instructions, superintendence of governor general, advocate general for province, provisions as to police rules, provisions as to crimes of violence intended to author government, and sources of certain information not to be disclosed in conduct of business of provincial government. Section 6 is constitution of provincial legislatures, composition of chambers of provincial legislatures, sessions of the legislature, prorogation and dissolution, right of governor to address and send messages to chambers. 64, rights of ministers and advocate general as respects chambers, officers of chambers, voting in chambers, powers of chambers to act notwithstanding vacancy and quorum, the provision as to member of legislature. Section 67, oath of members, vacation of seats, disqualification for membership, 70 is penalty for sitting and voting when not qualified is when disqualified, and 71 is privileges and members, 72 salaries and allowances of members, and then 73 is introduction of bills, and passing of bills in provinces having legislative council, assents to bills and bills reserved for constitution, and 77 power of Crown to dissolve acts. Then 70 is annual financial statement, 79 is procedure and legislature with respect to estimates, authentication of schedules of authorized expenditure, 81 is supplementary statements of expenditure, 82 is special provisions as to financial bills, 83 is provisions with respect to certain additional grants, and 84 is rule of procedures, English to be used in provincial legislatures, restrictions on discussions in legislatures, courts not to inquire into proceedings of legislature. Then 88 is powers of governor to promulgate ordinances during the session of legislature, power of governor to promulgate ordinances at any time with respect to certain subjects, power of governor in certain circumstances to enact acts, and then 891 excluded areas and partially excluded areas, administration of excluded areas and partially excluded areas. 93 is power of governors to issue proclamations, and then 94 chief commissioners of provinces, 95 British Balochistan, 96 Andaman and Nicobar Islands, 97 Guam, 98 provisions as the police rules assigned as to crimes of violence intended to overthrow government. Then there is 99 extent of federal and provincial laws, 100 is subject matters of federal and provincial laws, 101 is extent of power to legislate for states, and 102 is power of federal legislature to legislate if an emergency is proclaimed, and 103 is power of federal legislature to legislate for 2 or more provinces by consent, 104 is power of legislation, 105 application of naval forces discipline act to Indian naval forces, 106 provisions as to legislate for given legislation for giving effect to international agreements, 107 inconsistency with the federal laws and provincial and state laws, and 108 is sanction of government, sanction of governor general or governor required for certain legislative proposals, and 109 Act-Vandematram requirements as to sanction and recommendations to be regarded as matter of procedures only, and then 110 is saving, then 111 is British subjects to domicile in the United Kingdom, 112 is taxation, and 113 is companies incorporated in the United Kingdom, 114 is companies incorporated in India, 115 is ships and aircraft, 116 subsidies for encouragement of trade of industry, 117 is supplemental, 118 is power to secure reciprocal treatment by conventions, 119 is professional and technical qualification in general, 120 is medical qualification, 120 is officers of Indian medical services, etc. And then it's 122 obligation of units and federation, 122 is governor general may require governors to discharge certain functions as his agents, 124 is power of federation to confer powers, etc. on provinces and certain states in certain cases. 125 is administration of federal acts in Indian state, and 126 is control of federation over provinces in certain cases, 127 is acquisition of land for federal purposes, 128 is duty of a ruler of a state as respect the federal subjects, and 129 is broadcasting, 130 is complaints as to interference with water supplies, 131 is rescission of complaints, and 132 is interference with water supplies of chief commissioners of the province, 133 jurisdiction of course excluded, 134 is ruler of state may exclude applications of provisions as to water supply, and then 135 is provisions with respect to an inter-provincial council, and then it is you can say 136 is meaning of revenues of federation, meaning of revenues of federation and the revenues of provinces. 137 is certain succession duties, stamp duties, terminal taxes and taxes on fares and freights. Section 138 taxes on income. Section 139 is corporation tax, and 140 is all duties, access duties, and export duties. 141 is prior sanction of governor general required to bills affecting taxation in which provinces are interested. 140 is grants from federation to certain provisions. Provinces. 140 is saving, 140 for calculation of net proceeds, and 145 expenses of crown in connection with Indian states. Section 146 is payments from by Indian states. Section 147 is remission of states contributions, and Section 140 certain payments to federated states to be charged on federal revenues. 149 is values of privileges and immunities to be set off against the shares of taxes assigned to federation states, and then 150 is expenditure deferable out of Indian revenues. 151 is provisions as to custody of public monies. 152 the exercise by Governor General of certain powers with respect to Reserve Bank. 153 is previous sanctions of Governor General to legislate with respect to Reserve Bank, currency and coinage, and then 154 is exemption of certain public property from taxation. Section 155 is exemption of provincial governments and rulers of federated states in respect of federal taxation. 156 is adjustment in respect of certain expenses and pension. 157 is duty of federation and provinces to supply secretary of state with funds. 158 is provisions as to relation of monetary system with India. 159 is relief in respect to tax on income taxable both in India and Burma, and 160 is provisions as to customs duties on India-Burma trade, and then 161 is cessation of borrowings by Secretary of State and Council. 162 is borrowings by federal government. 163 borrowing by provincial governments. 164 is loans by federal governments to federated state. 165 is application of Colonial Stocks Act to stocks issued by federation. 166 is Auditor General of India. 167 is Provincial Auditor General. 168 is power of the Auditor General of India to go directions as to accounts, and 169 is audit reports. 170 is Auditor of Indian Home Accounts, and 171 audit of accounts relating to discharge of its functions of Crown in relation to United States, and 172 vesting of lands and buildings, 173 is provisions as to other purposes, 174 is property accruing by each escheat or lapse or as bona vacantia. Then section 175 is power to acquire property and to make contracts, and 176 suits and proceedings, and 177 is existing contracts of Secretary of State and Council, 170 is special provisions as to existing loans, guarantees, and other financial obligations, 179 is legal proceedings as to certain matters, 180 is contracts in connection with fundamental functions of Crown in its relations with Indian states, and 181 the executive authority in respect of railways to be exercised by Federal Railways Authority, 182 is composition etc. of Railways Authority, 183 is directions and principles to be observed by Railway Authority, 184 is conduct of business between Railway Authority and Federal Government, 185 is acquisition, sale of land, contracts and working agreements, 186 is finances of Railway Authority, 187 is provisions as to certain obligations of Railway Authority, 180 is investment of funds of Railway Authority, 189 special provisions as to certain existing funds, and 190 is audit and annual reports, and 191 is railways rate committees, 190 is bills and amendments for regulating rates and fares to require recommendations of Governor General, 193 is obligation of railway authorities and federated state to afford mutual traffic facilities and to avoid unfair discrimination, etc. 194 is appeal by state to railways tribunals from certain directions of railway authority, 195 is construction of railways, 196 is railway tribunal, 197 rights of railway companies in respect of arbitration under contracts, and 190 railways in Indian states which have not federated, 199 official directions of Indian railway companies, and then 200 is establishment and constitution of federal court, 201 is salaries of judges, 202 temporary appointment of acting chief justice, 203 seat of federal court, 204 is original jurisdiction of federal court, 205 appellate jurisdiction of federal court and appeals from high court in British India, 206 is the power of federal legislature to enlarge appellate jurisdiction, 207 is appellate jurisdiction of federal court and appeals from high court and federal states, 208 appellate to His Majesty's and Council, and 209 is formal judgment on appeals, 210 is enforcement of decrees and orders of federal court and orders as to discovery, etc. 211 is letters of request to federated states, and 212 is law declared by federal court and a privy council to be binding on all courts, and then 213 is power of Governor General to consult the federal court, and 214 is rule of court, etc. 215 is ancillary power of federal court, 216 is expenses of federal court, 270 is construction of reference to the high court in states, and 218 is savings. 219 is meaning of high court, 220 is constitutional high court, 220 is salaries of judges, 222 is temporary and additional judges, 223 just jurisdiction of existing high court, 224 administration function of high court, 225 transfer of certain cases to high court for trial, 226 jurisdiction and revenue matters, 227 proceedings of high court to be in English, then 228 expenses of high court, 229 power of His Majesty to reconstitute the high court by letter patent, 230 is extra provincial jurisdiction of high courts, 231 savings and definitions, and 232 pay of communal commander-in-chief, 243 control of His Majesty as to defense appointments, 233 eligibility for commission in Indian forces, 235 control of Secretary of State with respect to conditions of service, 236 saving of rules, rights of appeal, 237 pay to members of forces to be charged on federal reservation revenues, 238 provisions as to certain civilian personal, 239 King's India cadetship. 240 is the tenure of office of persons employed in civil capacities in India, 241 recruitment and conditions of service, 242 application of proceeding sections to railway, customs, post and telegraph services and official in course, 243 special provisions as to police, 244 is service required by Secretary of State, 245 special provisions as to irrigation, 246 is reserved post, 247 is conditions of service, pensions, etc. of persons recruited by Secretary of State, 248 right in respect of complaints about appeals, and 249 compensation, and then 250 is application of fourth last preceding sessions sections to persons appointed by Secretary of State in Council and certain other persons. 251 staff of High Commander and Auditor of Indian Home Accounts. 252 is conditions of services of existing staff of High Commissioner and Auditor of Indian Homes. Then 253 judges of Federal Court and High Court. 454 is district judges. 255 subordinate civil judicial services. 256 the subordinate criminal magistrate. 257 officials of political department. 258 provisions for protection of existing offices in certain services. 250 is the provisions as to certain persons who are serving in or before 1924. 260 general provisions as to persons retiring before commencement of Part 3. And miscellaneous. 261 is Secretary of State to act with concurrence of his advisors. 261 eligibility for office of persons who are not British subjects. 263 joint services and posts. Then it is 264 Public Service Commission. 265 is compositions and staff of commissions. 266 functions of Public Service Commissions. 267 power of text and functions of Public Service Commission. And 268 expenses of Public Service Commission. Then 269 provisions as to chaplains, and then 270 indemnity for past acts, then 270 protection of public servants against prosecutions in such suits. 270 provisions as to payment of certain pensions and exemption of those pensions from taxation in India. 273 provisions as to 5 family pension funds. 274 is saving for certain funds acts. 275 persons not to be disqualified by sex for holding certain offices. 276 transitional provisions. 277 interpretation, and then 278 advisors to Secretary of State. 279 existing accounts of Secretary of State and Council with Bank of England. 280 is organization expenses of India Office. 281 is transfer of existing personnel. 282 is the contributions from revenues of Federation. 283 is the liability and pensions in respect of services before commencement of Part 3. Provisions as to certain India Office provident funds, and then 285 saving for rights and obligations of Crown in its relations with Indian states. 286 use of His Majesty's forces in connection with discharge of functions of Crown in its relations with Indian states. And 287 arrangement for governors and provincial staff to assist in discharging functions of political department. And 280 is add-in. And 289 is creation of new provinces of Sindh and Orissa. 290 creation of new provinces of alteration to boundaries of provinces. 291 power of His Majesty to make provisions with respect to franchises and elections. And 292 existing law of India to continue in force. 293 adaptations of existing Indian laws. 294 foreign jurisdiction. 295 provisions as to death sentences. 296 courts of appeal in revenue matters. 297 prohibition of certain restrictions on internal trade. 298 persons not to be subject to disability by reason of race or religion. 299 compulsory acquisition of land. 300 protection for certain rights, privileges and pensions. And 301 is repeal of 18 of 21 GO 370 and still of 37,142. And 302 High Commissions of India. 303 provisions as to Sheriff of Calcutta. 300 persons acting as Governor General of Governor. 305 Secretary of Staff of Governor General and Governor. 306 protection of Governor General, Governor or Secretary of State. 307 removal of certain disqualifications on occasion of first elections to legislature. 308 procedures as to respects proposals for amendment of certain provisions of Act and orders in Council. 309 orders in Council. 310 power of His Majesty in Council to remove difficulties. 311 is interpretation. Then 312 is the operation of Part 13. 313 executive government. 314 control of Secretary of State. 315 sterling loans. 316 legislature. 317 continuance of certain provisions of Government of India Act. 318 provisions as to federal court and certain other federal authorities. And then 309 rights and obligations, liabilities of Governor General in Council and Governor General to continue after establishment of federation. Then 320 is commencement, 320 is repeals, and then first schedule composition of federal legislature. Second, schedule provisions of this act which may be amended without affecting accession of the states. And then Schedules are there. Third schedule, provisions as to Governor General and Governors of Provincial. Fourth schedule, forms of office and information. Fifth schedule is composition of provincial legislatures. Sixth schedule, provisions as to franchise. And seventh schedule, legislative lists. Eighth schedule is federal religious authority. Ninth schedule, provisions of Government of India Act continued in force with amendments until establishment of federation. And 10th schedule, enactment repeal. These were index. Now what this page says on top, an act to make further provisions for Government of India, be it enacted by King's Most Excellent Majesty, by and with advice and consent of Lords spiritual and temporal and commons in this present Parliament assembled, and by authority of same as follows. This act may be cited as Government of India Act 1935, and all rights, authority, and jurisdiction heretofore belonging to His Majesty King Emperor of India, which appertain or are incidental to government of territories in India for time being vested in him, and all rights, authority, and jurisdiction exercisable by him or in relation to any other territories in India are exercisable by His Majesty, except in so far as may be otherwise provided by or not under this Act, or as may be otherwise directed by His Majesty, provided that any power connected with exercise of functions of Crown in its relations with Indian states shall in India, if not exercised by His Majesty, be exercised only by persons acting under authority of His Majesty's representative for exercise of those functions of Crown. Said rights, authority, and jurisdiction shall include any right, authority, or jurisdiction heretofore exercisable in or in relation to any territories in India by Secretary of State in Council, Governor General in Council, any governor or any local government, whether by delegation from His Majesty or otherwise. Governor General of India is appointed by His Majesty by commission under royal sign manual, and so this was manual. Then we had gone through Federation of India Part 2, which was related to proclamation of Federation of India. Then it was for, you can say, various other provisions. We moved them. We reached, you can say, Accession of India Acts, and we have, I was here, I think it was, you can say, I have crossed 100 sections of this Act, and we have to start from there. So far I was just explaining the background of this, which was very, very, you may say, required. First, make preliminary understanding about what it is. I'm finding this, where is this 49 has come only. Let us see how can we fast move on this. Let's move on. So I'm saying this is 7984. So I am going to reach 100. I think that was about 100. Yes, it was 114. So it is 114. Let us start and see. So it was companies matters were going on. Still companies in 14. I'll leave companies only to talking to companies. No meaning at all. Talking to level sentence supplemental. Then we can say professional and technical qualification we have studied and we have gone through. Medical qualification we have gone through. Let us say obligation was at 122. Administrative relations between federation, provinces, and state. It is section 122. Let us just have a paragraph read of these obligations of units and federation. Executive authority of every province and federated state shall be so exercised as to secure respect for the laws of federal legislature which apply in that province or state. Reference to subsection of this section to laws of federal legislature shall in relation to any other province include the reference to any existing Indian law. So this is the same. So let's move further. Governor General and all this is there. We will leave it now. 125 is there regarding administration of federal acts in Indian states. So, and means 125 simply just give one line. Notwithstanding anything, Notwithstanding anything in this Act, agreements may or if provisions have been made in that behalf by instrument of accession of state shall be made between Governor General and ruler of federated state for the exercise by ruler or his officers of functions in relation to administration in his state or of any law of federal legislature which applies therein. Take out this. So next one is 126 control of federation. Leave this behind. Then it is I'm just going to 127 acquisition of land. Then 128 duty of ruler. Leave all this. Then broadcasting. What broadcasting says? Let us see. This broadcasting is what is in 129. It is federal government shall not unreasonably refuse to entrust to the government of any province or ruler or any federal state such functions with respect to broadcasting as may be necessary to enable government or ruler to construct and use transmitters in province or to regulate and impose fees in respect of construction and use of transmitters and use of receiving apparatus in province or state, provided that nothing in the subject. Nothing subsection shall be construed as requiring the federal government to entrust to any such government or ruler any control over use of transmitters constructed or maintained by federal government or by persons authorized by federal government or over use of receiving apparatus by persons so authorized. Then any function so entrusted to a government or ruler shall be exercised subject to such conditions as may be imposed by federal government, including notwithstanding anything in this act, any coordination with respect to finance, but it shall not be lawful for federal government to impose any condition regulating matter broadcast by or by authority of government of rulers. Any federal laws which may be passed with respect to broadcasting shall be such as to secure that effect can be given to foregoing provisions of this section. If any question arises under this section, whether any conditions imposed on any such government or ruler are lawfully imposed, or whether any refusal by federal government to entrust the functions in unreasonable question shall be determined by Governor General of his discretion. So it's like that. 130 is complaints as to transfer with water supplies. Say 130, if it appears to government of any governor, province, or to ruler of any federal state that interest of that province or state or of any of inhabitants thereof in water from any natural source of supply in any governors or chief commissioners province or federated state have been or are likely to be affected prejudicially by any executive action or legislation taken or passed or proposed to be taken or passed or failure of any authority to exercise any of their powers with respect to use, distribution, or control of waters from that source, government or ruler may complain to Governor General. The 137 decision of complaints. Let's go through this. If Governor General receives such a complaint as a force, he shall, unless he is of opinion that issues resolved are not of sufficient importance to warrant such action, appoints a commission consisting of such person having special knowledge and expertise in irrigation, engineering, administration, finance, or law, as he thinks fit, and requests that commission to investigate in accordance with his instructions as he may give to them and report to him on matters to which complaint relates to, or such those matters as he may refer to them. And the commission so appointed shall investigate matters referred to them and present to Governor General a report setting out facts as found by them and making such recommendations as they think proper. And if it appears to Governor General upon consideration of Commission's report that anything there is contained requires explanation of that and needs guidance upon any point not originally referred by him to Commission, we again refer matter to Commission for further investigation and a further report. And for the purpose of assisting commission appointed under this section investigating any matters, refer to them. Federal court, if requested by commission so to do, shall make such orders and issue such letters of request for purpose of proceeding of commission as they may make or issue in exercise of jurisdiction of court. After considering any report made to him by commission, Governor General shall give such decision and make such order, if any, in matter of complaint as he may deem proper. Provided if before Governor General has given any decision, government of any province or ruler of any state affected request him so to do, he shall refer matter to His Majesty in council, and His Majesty in council may give such a decision and make such order, if any, in matter as he deems proper. Effect shall be given in any province or state affected to any order made under this section by His Majesty in Council or Governor General, and any act of provincial legislature or a state which is repugnant to order shall to extent of repugnancy be void. Subject as hereinafter provided, Governor General application made to him by government of any province or ruler of any state affected may at any time, if after a reference to a report from a commission appointed as aforesaid by considers it proper so to do, vary any decision or order given or made under this section. Provided that where application relates to a decision or order of His Majesty in Council, and in any way, in any other case, if the government of any province or ruler of any state affected request him so to do, Governor General shall refer matter to His Majesty in Council, and His Majesty in Council may, if he considers it proper, so to do, vary decision or order. So, an order made by His Majesty in Council or Governor General under this section may contain directions as to government or persons by whom expenses of commission and any costs incurred by province, state, or persons in the appearing before commission are to be paid, and may fix amount of any expenses or costs to be so paid, and so far as it relates to expenses or costs may be enforced as if it were an order made by federal court. Functions of Governor General under this section shall be exercised by him in his discretion. And 132 is interference with water supplies of chief commissioners of province. Leave it, something else. Then we go to 133, jurisdiction of courts excluded. And 134, ruler of state may exclude application of provisions as to water supply. Let's go further away. 135, which is provisions with respect to an inter-provincial council. Let us see what is this. 135, if at any time it appears to His Majesty upon consideration of representations addressed to him by Governor General that public interest would be served by establishment of an inter-provincial council charged with the duty of inquiring into advising upon disputes which may have arisen between provinces, investigating, discussing subjects in which some or all of provinces or federation and one or more provinces have a common interest, making recommendations upon any such subject, and in particular recommendation for better coordination of policy and action with respect to that subject. It shall be lawful for His Majesty in Council to establish such a council and to define nature of duties to be performed by this council and its organization and procedures. An order establishing any such council may make provision for representatives of Indian states to participate in work of council. Finances, I think is 136, meaning of revenues of federation, leave finances, no need. Then there's also certain sections, duties stamp, leave it, duties stamp, and then taxes we leave, then no need of then taxes, no meaning at all here. And we'll go to corporation tax, we leave this corporation tax also. Then salt duties, leave it. Then Prior sanction of government general required to bills affecting taxation which provinces are interested. Let us see just one paragraph of this what about the 141, section 141. No bills or amendment which imposes varies in the text of duty in which provinces are interested, or which varies meaning of expression, agriculture income as defined for purpose of enactment relating to Indian income tax, or which affects principles on which under any of foregoing provisions of this chapter monies are or may be distributed to provinces or states, or which imposes any such federal surcharge as is mentioned in in foregoing provisions of this chapter shall be in introduced or moved in either chamber of federal legislature, except with provisions sanctions of Governor General in his discretion. So we'll leave it here. We'll go to other one. This is 142. Grants from federation to certain provinces. 143 savings. 144 is calculation of net proceeds. And 145 expenses of crown in connection with Indian estates. Let us see one paragraph of this 145. There shall be paid to His Majesty by Federation each year sum stated by His Majesty's representative for exercise of functions of Crown in relation to the Indian states to be required, whether or revenue account or otherwise for discharge of those functions, including making of any payments in respect of any customary allowances, members of family and servants of any farmer ruler of any territory in India. The not one versus payments from or Indian states later on remission of a state's contribution. Okay, we'll just go further then. It is then you go to where all this 148 certain payment to federated state to which charge on federal revenues. We solve this value of privilege and immunity to set of action against share of taxes and assigned to federated states. Then where under foregoing provisions of this chapter is made any year by federation to federal state. 150 expenditure deferable, okay. 150 on provisions as to rules may be given. Custody of public money. What it says. 151 provision as to custody of public money. So the rules may be made. This section 151. Rules may be made by governor of province, governor of provisions, general, and by governor of province for purpose as to secure all monies received on account of revenues of federation. All right. 152 exercise by Governor General of certain powers with respect to Reserve Bank. What is that? Let us see. 151. Function of Governor General with respect to the following matters shall be exercised by him in discretion, that is to say, appointment and removal from office of Governor and Deputy Governor of Reserve Bank of India, approval of their salaries and allowances, and fixing of their terms of office. Appointment of an officiating governor or deputy governor of bank. Supersession of central board of bank and any action consequent thereon, and liquidation of bank. In nominating directors of Reserve Bank India and in removing from office any direction nominated by him. Governor General shall exercise in his individual judgments. Then 153 is provision section of Governor General legislation with respect to the rank, concerning coinage. No bill or amendment which affects coinage or currency of federation of constitution or functions. The Reserve Bank of India shall be introduced into or move in either chamber of federal legislature without previous sanctions of the government. And 154 exemption of certain public property from taxation. Property vested in His Majesty for purpose of government or of federation shall save in as so far any federal law may otherwise provide exempt from taxes imposed by or by any authority within a province for federal states. Okay. And move to 51, 55, exemption of provincial governor, ruler of federal state. I think it's on not relevant to politics. Adjustment of respect to certain pensions. Then we can say the duty of federal and provincials to supply Secretary of State with funds. 157.1 Federation and every province shall secure that there are from time to time in hands of Secretary of State sufficient money to enable him to make such payments as he may have to make in respect of any liability which falls to be made out of revenue of federation or province as to case may be. This was something out. Okay. Then we'll go to someone else. The provision 158 provisions as to relation of Burma monetary system with India. What is that? Let us see 158. His Majesty in Council. His Majesty in Council may make such provisions as may appear to him to be necessary or proper for defining and regulating the relation between monetary system of India and Burma and for purposes connected with or ancillary to those purposes, and in particular but without prejudice to generality of this section, such provisions as may appear to His Majesty to be necessary or proper for the purpose of giving effect to any arrangement with respect to said matters. Said matters made before commencement of Part 3 of this Act with approval of Secretary of State by Governor of Burma in Council with Governor General in Council or any other persons. Alright, go to then any sums required by an order under this section to be paid by federal shall be charged in revenue of federation. Then 159 relief in tax of His Majesty in Council will make provisions for the grant of relief from any federal tax on the income of respective income tax or taxable in Burma. Sub 160. Sorry. Provisions as to custom duties in India Burma trade with a view to preventing undue disturbance of trade between India and Burma in period immediately following the separation of India and Burma, and with a view to safeguarding economic interests of Burma during that period. His Majesty may by order in Council give such directions as he thinks fit for those purposes with respect to duties which are, while order is enforced, to be levied on goods imported into imported into or exported from India or Burma, and with respect to ancillary and related matters. Now it is borrowing of accounts means cessation of borrowing by Secretary of State and Council. The 161, it is upon commencement of Part 3 of this Act, all powers vested in Secretary of State in Council of borrowing on security of revenue of India shall cease and termine, but nothing in this section affects the provisions of Part 13 of this Act with respect to borrowings and sterling by Secretary of State. The 162 is borrowing for federal government, subject to provisions of Part 13 of this Act with respect to borrowing in sterling. Executive authority of Federation extends to borrow upon security of revenue of Federation with such limits, if any, as may from time to time be fixed by act of federal legislature, and to giving of guarantees within such limits, if any, as may be so fixed. 163. Subject to provisions of this section, the executive authority of province extends to borrowing upon security of revenues of province within such limits, if any, as may from time to time be fixed by act of provincial legislature, and to giving of guarantees within such limits, if any, as may be so fixed. I will move further on this. Then we'll go further. 164. Federation is subject to loans by federal government to federal states. 164. Federation may, subject to such conditions, if any, as it may think fit to impose, making loans to or so long as any limits fixed under last but on proceeding section are not exceeded, giving guarantees in respect of loans raised by any federated state. Sorry, cold actually. 165 is application of Colonial Stock Acts to stocks issued by Federation. Colonial Stock Acts 1877 to 1900 shall not, withstanding anything to contrary in this act, apply in relation to sterling stock issued after establishment of Federation and forming part of public debt of Federation, as they apply in relation to stock forming part of public debt of any British possession mentioned in those acts. So, however, that nothing in this section 20 of Colonial Stock Act 1877 shall be construed as compelling a person desirous of bringing proceedings to proceed in manner therein specified, and that until Parliament otherwise determines any condition prescribed by the Treasury under sections 2 of Colonial Stock Act 1990 shall be determined to have been complied with respect to all such stock so showed by Federation, and expression colonial stock in section 11 of Trust Scotland Act 1921 shall include any stock in relation to which said acts apply by virtues of this section. And then it continues. So we'll go to 166, which is audits and accounts. Auditor General of India. 166. There shall be an Auditor General of India who shall be appointed by His Majesty and shall only be removed from office in like manner and on the like grounds as a judge of federal court. So this is actually nowadays this is CAG. Then conditions of service of Auditor General shall be such as may be prescribed by His Majesty in council, and he shall not be eligible for further office under Crown in India after he has ceased to hold his office, provided that neither salary of an Auditor General nor his rights in respect of leave of absence, pension, or age of retirement shall be varied to his disadvantage after his appointment. Auditor General shall perform such duties and exercise such powers in relation to accounts of Federation and of provinces as may be prescribed by or by rules made under an order of His Majesty in Council or by any subsequent act of federal legislature varying or extending such an order. Provided no bill or amendments for purpose of force shall be introduced or removed without previous sanctions of Governor General in his discretion. Then shall he announce and leave that. Then 167 Provisional Auditor General. So Provincial Auditor General 167. If a provincial legislature after expiration of 2 years from commencement of Part 3 of this Act passes an act charging salary of an Auditor General for that province on revenues of province, and Auditor General A province may be appointed by His Majesty to perform same duties and exercise same powers in relation to audit of accounts of province as would be performed and exercised by Auditor General of India if another general of province had not been appointed. Provided no appointment of another general in the province shall be made until expiration of these 3 years from date of Act of Provincial Legislature by which provision is made for the Auditor General of that province. Then provisions of last proceeding sections, I'll leave them. You know it. Then we come to Section 168, which is powers of Auditor General of India to give directions as to accounts. Accounts of Federation shall be kept in such form as Auditor General of India may, with approval of the Governor General, prescribe, and insofar as Auditor General of India may, with like approval, give any directions with regard to methods or principles in accordance with which any accounts of provinces ought to be kept. It shall be duty of every provincial government to cause accounts to be kept accordingly. 169. Audit reports. Reports about the General of India relating to accounts of Federation shall be subjected to Governor General, who shall cause them to be laid before Federal Legislature, and reports of the General of India or of the General of Provinces, as case may be relating to accounts of province, shall be submitted to Governor of Province, who shall cause them to be laid before Provincial Legislature. 170. Auditor of Indian Home Accounts. There shall be an auditor of Indian Home Accounts who shall be appointed by Governor General in his discretion, and shall only be removed from office in a like manner and on like grounds as a judge of federal court. Condition service of Auditor General consensus. Then we'll move further. Further, that one is. 171 will go. So audit of accounts relating to discharge of functions of Crown in relation to Indian states. So I think it's 171. That's it. Accounts relating to discharge of functions of Crown in relations with Indian states shall be audited by Auditor General of India, or insofar as those accounts concern transactions in United Kingdom by Auditor General, Auditor of Indian Home Accounts, acting on his behalf and under his general superintendence, and Auditor General of India shall make to Secretary of State annual reports on accounts so audited by him on behalf. Property, contracts and liabilities, I of 172, vesting of lands and buildings. All lands and buildings which immediately before commencement of Part 3 of this Act were vested in His Majesty for purposes of Government of India shall, as from that date. In case of lands and buildings which are situated in a province, vest in His Majesty for purpose of government of that province, unless they were then used. Otherwise, then under a tenancy agreement between Governor General and Council and Government of the province, for purpose which thereof will be purpose of federal government of His Majesty's representatives for exercise of functions of Crown in relations with Indian states, unless they are lands and buildings formally used for such purposes as aforesaid, or intended or formally intended to be so used, and are certified by Governor General in Council, or as case may be, His Majesty's representative to have been retained for future use for any such purpose, or to have been retained temporarily for purpose of more advantageous disposals by sale or otherwise. So we'll go to 173, the provisions as to other property. Let's see what it says. 173. I am on page 125 of 341. Subject to provisions of this and last is preceding section, all property vested in His Majesty, which by virtue of any delegation from Secretary of State in Council or otherwise is immediately before commencement of forty of this Act in possession or under control of or held on account of this government, the regional council or any local government shall, as from commencement of Part 3 of this Act, vest in His Majesty, for purpose of government of foundation, for purpose of exercise of functions of crown. We'll go to next one, which is 174, property accruing by escheat or lapse or a bona vacancy. What it says, let's see. So I'm leaving many documents, many paragraphs which are not related to section directly, and you can read them successfully when you check from that book. Subject hereinafter, provided and property of India accruing to His Majesty by escheat or lapse or as bona vacantia for want of a rightful owner, shall, if it is property suitable, situated in a province west in His Majesty for purpose of government of that province, shall in any other case west in His Majesty for purpose of government of federation, provided any property which at date when accrued to His Majesty was in possession or under control of federal government, as government of a province shall according as the purpose for which it was then used or held for purpose of federation or of a province west in His Majesty for purpose of government of federation. Okay. Then 175 is power to acquire property and to make contracts. Let us see this also a common one. 175, section 175. Executive authority of federation and of provinces shall extend subject to any act of appropriate legislature to grant, sale, dispose, or mortgage of any property vested in His Majesty for purpose of government, of federation, or of province, as case may be, and to purchase or acquisition of property on behalf of His Majesty for those purposes, respectively, and to making of contracts. 176, suits and proceedings, leave suits and proceedings. 176, existing contracts of secondary of state and council. Existing contracts of Secretary of State in Council versus without prejudice to special provisions of next succeeding section relating to loans, guarantees, and other financial obligations, any contract made before commencement of Part 3 of this Act. I think we have to move further. 178, special existing laws, guarantees, and other financial adjusting, let's say, 178, all liabilities in respect of such loans, guarantees, and other financial obligations of Secretary of State and Council as are outstanding with Jyete before commencement of Part 3 of this Act and were described, secured on revenues of India shall, as from that date, the liabilities of federation and shall be secured upon. Okay. 179 legal proceedings as to certain matters. Leave it behind. I'll speak only which I think is better for current topic. Contracts in connection with functions of Crown in its relations with the United States. And we see Act 181, executive authority respect of railways to be exercised by Federal Railways Authority. Let's leave the other, this was Federal Railways Authority. Executive authority of Federation in respect of regulation, construction, maintenance, and operation of railway shall be exercised by Federal Railway Authority. Hereinafter referred to as authority. Said executive authority extends to carrying on in connection with any federal railways of such undertakings as, in opinion of authority, is expedient, should be carried on his connection therewith, and to make and carrying into effect of. Okay, then we go to 182 composition railway authority. Let's go railway authority. No less than 3/7 of members of authority shall be a person appointed by court. Shall no less than 330, 370, 377, 370. Yeah. We move further. Now 183 elections, principles of the railway authority. It says 183. Authority in discharging their functions under this Act shall act on business principles due to regard being held by them to the interest of agriculture, industry, commerce, and general public, and in particular shall make proper provision for meting out of their receipts or revenues according to expenditure to which such receipts are applicable under provisions. We go to 184. Conduct of business with railway authorities and federal government. Aggregation. Sales of okay. 185 is no meaning, Financial, I think I'll move further, closing this one. This is financing of 188, if investment of funds or so on, nothing in this following special provisions of certain existing current funds. 190, this is audit and annual reports. 191, railway rates, Rameshri. Appeal by state to railways, I think I'm getting bored here. 195 is construction and reconstruction railways. That says construction and reconstruction of railways. What does it say? Article 195. Governor General acting in this direction shall make rules requiring entry authority and any federal state to give notices in such cases as rules may prescribe of any proposal for constructing a railway or for altering alignment or gauge of a railway to dispose plan of the substance. Rules made shall contain provisions enabling objections to be lodged by the authority or by a federated state on ground that carrying out of proposal will result in unfair or uneconomic competition with a federal railway or state railways as case may be, and if an objection so lodged is not withdrawn withdrawn within prescribed time, Governor General shall refer to railway tribunal, question whether proposal ought to be carried into effect without modification or with such modification as tribunal may approve. All right. Railway Tribunal. What is Railway Tribunal? 196. There shall be Railway Tribunal. The Railway Tribunal in this Act for the Railway Tribunal consists of President and two other persons to be selected in each case by Governor General in his discretion from a panel of 8 persons. 196. Okay, tribunal. Let me go further. This is this is Governor General of Rights of Ways, yeah, Railways Institution of Judiciary. Judicature. Article 200. Establishment and Constitution of Federal Court. There shall be a federal court consisting of a Chief Justice of India and such number of other judges as His Majesty may deem necessary. But unless and until an address has been presented by federal legislature to Governor General for submission to His Majesty, praying for an increase in number of judges, number of puisne judges shall not exceed 6. Every judge of federal court shall be appointed by His High Majesty, by every judge but unless and until an address has been presented by federal legislature to Governor General for submission to His Majesty, praying for an increase in number of all right. Every judge of a federal court shall be appointed by His Majesty by warrant under royal sign manual and shall hold office until he attains age of 65 years. A judge may by resignation underhand addressed the Governor General resign his office. A judge may be removed from his office. All right. Let's go through something else. I mean, you said it here. No need to go further. Let's see what's there next. (2066) Federal legislature may be by this act, provide that in such civil cases as may be specified in the act. All right. All this is judges. All judges. Okay, 17 means it's nothing of a new letters of request to federated states. This 212, this is law declared by federal court and Privy Council to be binding on all courts. Mm. 212, law declared by federal court and by any judgment of Privy Council shall so far as not law declared by federal court and any judgment of Privy Council shall so far as applicable be recognized as binding or shall be followed by all courts in Britain. Right. Then okay. Hmm. Power of Governor General to consult Federal Court 213. If at any time it appears to Governor General that a question of law has arisen or is likely to arise, which is of such a nature and of such public importance that it is expedient to obtain opinion of federal court upon it. He may in many discussions, refer to questions with that court may court to follow consultations and, and, and the court may after such and think the fact report to General Governor General. Then this is rules of court. Rules of court is 214. Right? Rules of court 214. Federal court may from time to time, with approval of Governor General in his direct discretion, make rule of court for regulating generally practice and procedure of court, including rules as to persons practicing before a court, as to time within which appeals to court are to be entertained, as to cost of and incidental to cost, any proceeding in court, and as to fees to be charged in respect of proceedings therein, and in particular may make rules providing for community summary determination of any go further. Rule 215, ancillary powers of federal code. Number ancillary powers. See the federal codes. Federal legislature may make provision by act for conferring upon federal courts such supplemental powers not inconsistent with any of provisions of this act as may appear to be necessary for desirable for purpose of enabling court no more effectively to exercise jurisdiction conferred upon by under this act. 216 expenses of federal courts, leave expenses of that, then it's the meaning of that. Then construction of references to High Court states. 217. References in any provision of this part of this Act to High Court and federal states shall be constructed as references to any court which state shall be construed as a referendum to any court which has majesty, His Majesty may, after communication with the ruler of that state, declare to be a high court for principle of that. Wherein is savings. Nothing in this chapter shall be construed as conferring or empowering federal judge legislature to confer any right of appeal to the federal court in any case which a high court causes. Alright. High Court in British India, leave it. Let us see what is the meaning of High Court. Otherwise, we will move further. It's 219. Following courts shall, in relation to British India, be esteemed to be High Courts for purpose of this Act. That is to say, High Court in Calcutta, Madras, Bombay, Allahabad, Lahore, and Patna, Chief Court in Oudh, and Judicial Commissioners Court in Central Provinces, and Berar in Northwest Frontier Province and in Sindh. Any other court in British India constituted on or reconstituted under this chapter as to High Court and vary any other any other comparable court in British India which has majesty in council may many declare to be a high court of all. Then, provided that provisions have been made before commencement of Part 3 of this Act for establishing a High Court to replace any court or court mentioned in this subsection then is from establishment of new code, this section shall be affected as if. In new code, what mentioned therein, in lieu of court, course, or alright, then we'll leave it Constitutional High Court, we'll leave this. We'll go further. Transfer of certain cases to High Court, leave it also. The same thing they are taking all consideration, revenue matters, then I suppose all High Courts are moving here. Um, Yeah, to the kings in the affairs, yeah. King's India Cadetships 239 in appointment of officers to His Majesty's Army, same provisions as heretofore equal provision shall be made for appointment of sons of persons who have served in India in military or civil services of Crown. Well, civil services, let us say what civil services are about here. Civil services, section 240. Except as expressly provided by this Act, every person who is a member of civil service of Crown in India or holds any civil post under Crown in India, holds office during His Majesty's pleasure, no such person, as aforesaid, shall be dismissed from service of His Majesty by any authority subordinate to that by which he was appointed. No such person as aforesaid shall be dismissed or reduced in rank until he has been given reasonable opportunity of showing cause against action proposed to be taken in regard to him, provided that this subsection shall not apply where a person is dismissed or reduced in rank on ground of conduct which has led to his conviction on a criminal charge, where an authority empowered to dismiss a person or reduce him in rank is just satisfied with for some reason to be recorded by that authority in writing. It is not reasonably practicable to give to that person an opportunity of showing cause. Notwithstanding that person holding a civil post under Crown in India holds office in civil post under Crown of India holds office during His Majesty's pleasure. Any contract under which a person not being a member of civil service of Crown in India is appointed yeah, recruitment and condition service shall be. You know what we are there. You see. Important now. Then it is, I'm just going to scanning the application of press interaction railway select. Social provisions as the police, what it says. Notwithstanding anything in foregoing provisions of the chapter, conditions service of subordinate ranks of various police forces in India shall be such as may be determined by under acts relating to those forces respectively. What service departments we have here? Special provisions to irrigation. Special provisions to irrigation. 245. 245. Until Parliament otherwise determines, Secretary of State may, for purpose of securing efficiency in irrigation in any province, appoint persons to any civil service or of civil post under Crown India concerned with irrigation. Reserve posts. What are reserve posts? Let us say reserve posts. Secretary of State shall make rules specifying number and character of civil posts under Crown, other than posts in connection with any functions of Governor General, which Governor General is by or under that Act required to exercise in discretion, is subject to provisions of this subscription are to be filled by persons appointed by Secretary of State in a civil service or a civil post under the Crown of India in India, and except under such conditions as be prescribed. Okay, then go further, leave it there, no meaning. Condition service अच्छा हो पड़े यार, condition service. We'll go to rights and respect of complaints and appeals. Let us see what this is for 48. If any person appointed to a civil service or civil post by Secretary of State is aggrieved by any order affecting his conditions of service and on undue application to person by whom order was made does not receive redress, which considers himself entitled, he may without prejudice to any other mode of obtaining redress, complain if he is serving in connection with affairs of federation to the Governor General. He may not prejudice to any other mode of obtaining redress, complain if he is serving in connection with affairs of federation to Governor General, and if he is serving in connection with affairs of province to Governor of province. And Governor General or Governor, as case may be, shall examine into complaint and cause such action to be undertaken thereon as appears to him, exercising his individual judgment to be just and equitable. This we'll go, I think, main as in compensation, leave compensation. I think 251 State of High Commissioner, Staff High Commissioner, like Conditional Service, all these things, Staff High Commissioner, leave that. Well, I think we have covered major points on judges of federal courts, high courts. Subordinate criminal magistrate. Subordinate criminal magistracy, what it says, Article 256. No recommendation shall be made for grant of magistral powers or of enhanced magistral powers to or withdrawal of any magistral powers from any person, save after consultations with the magistrate of states or the district in which he is working or with chief presidency magistrate, as case may be, officers of political department. Move further, leave it. Provisions of protection of existing officers of certain services. Only provisions of certain services for yeah. General provisions of persons retiring before commencement of Act 2. Except as otherwise explicitly provided in this chapter, any person payable to or in respect of any person who having been appointed to civil services of or a civil post under Crown in India retired from service of his magistrate before commencement of Part 3 of this Act shall we okay, sure. I'm not finding any big point in this. Analysis and course. Public Service Commission, let us go through this. 264. Subject to provisions of this section, there shall be Public Service Commission for Federation and for state. Public Service Commission 264. Subject to provisions of this section, there shall be a Public Service Commission for for uh, right, subject to provisions of this section, there shall be Public Commission Service Commission for Federation and the Public Service Chairman for each state. Then leave it. I don't think composition of a staff commission alone. Right. Power action functions Public Service Commission. I'm not finding any very specific in this. Actions Public Service Commission, chaplains. There may have been establishment of chaplains to Ministry of India. Be appointed by Secretary General, Secretary of State, and provisions of Chapter 2 of this part of this Act shall, with any necessary modification, apply in relation to that establishment and Okay. Chaplain's choice. Yeah, chaplain. Yeah. General, no proceedings circumstance indemnity for past acts. Then protection of public servants against prosecution rules. I think nothing is important in this. This is provisions of family pension funds. The that family pension fund. I should need to close this. Which should not be disqualified. Pensions not to be disqualified by sex for holding offices. And, part of this India interpretation is expression. All India service, central service, 277, all India service, central service class 1, central service class 2, railway service class 1, railway service class 2, and provincial services mean respectively services which are immediately before commencement of part 3 of this act, so described respectively in classification rules being then enforced under section 96B. And then existing count of secretaries in council, I think there's no need move further, I think. Contribution from revenue federation, liability pensions or to utilize creation of new province of Sindh and Orissa receives this as from such date as His Majesty may order in council. Sindh shall be separated from Presidency of Bombay. Sindh shall be celebrated from Presidency of Bombay. So Sindh was Presidency of Bombay and shall form a governor province to be known as Province of Sindh. Sindh and Bombay are related, this means, okay. Orissa and such other areas in province of Bihar and Orissa and as may be separated, specified in order of majesty, shall be separated from province and shall such areas may be specified in said order shall be separated from presidency of Madras and central provinces of Delhi. Then creation of new provinces and alterations. Okay, let us see. The 90 subject to provisions of this section is Majesty may by all council create a new province, increase area of any province, diminish area of any province, alter boundaries of any province. 91 power of His Majesty to make provisions respective franchise and elections. That is in 291. Insofar as provision with respect to matters hereinafter mentioned is not made by this Act, His Majesty in Council may from time to time make provision with respect to those matters or any of them. Delimitation of territorial constituencies. Delimited constituencies for purpose of election, qualification entitling persons to vote in territorial, qualifications entitling persons to vote in territorial or other constituencies and such election and provision of electoral roll. Qualifications for being elected at such elections as a member of legislative body and filling of okay, filing of casual vacancies in any such body, elections under this act express considerations such as all right, later. Okay. Hmm. Filling of casual vacancies in such body, expenses of candidates as selection, corrupt practices, and the offenses, addition of those. Okay, look. 292 is existing law of India to continue its force. Yes. Notwithstanding repealed by this Act of Government of India Act, but as subject to other provisions of this Act, all laws in force of British India immediately before commencement of Part 3 of this Act shall continue in force in British India until altered, repealed, or amended by a competent legislature or other competent authority. Right. Existing lies continuing adoption existing Indian laws. Agency by order and council made at any time after passing this act, provided as from such date as may be specified, that any law in force in British India or in any part of British India shall, unless repealed or amended by a competent legislature or other competent authority, have effects subject to such foreign jurisdiction. Hmm. Foreign jurisdiction. Okay. We are going to I'm not going to 295 provision issue death sentence. Let us see this important one. Where any person has been sentenced to death in a province, the Governor General in his discretion shall have all such powers of suspension, remission, or commutation of sentence as were vested in Governor General in Council immediately before commencement of Part 3 of this Act. But, right, Okay. So this is the sentence which I said that but saves as a forces of the okay, we have a person has sentence on that and prevents the gun channel in this case shall have all such power as well, but we have the sentence, okay, no problem. And we have 296 courts of appeal in revenue matters. No provincial legislation, the government shall prohibition of certain restrictions on internal trade. Then the persons not to be subject to disability by reason of race, religious. So House put 298, no subject of His Majesty domicile in India shall be on grounds only of religion, place of birth, descent, color, or any of them be ineligible for office on the ground in India or be prohibited on any such grounds from acquiring, holding, or disposing of property or carrying on any occupation, trade, business, or profession in British India. Notwithstanding in this section shall affect the operation of any law such. So this is leave it now. Then we say 299, which is compulsory acquisition of land. No person this my boy is very problematic, you know. No person shall be deprived of his property in British India save by authority of law. Neither federal nor provincial legislature shall have power to make any law authorizing compulsory acquisition of public purposes of any land or any commercial or industrial undertaking or any interest or in any company owning any commercial or industrial undertaking unless law provides for payment of compensation for property acquired and either fixes amount of compensation or specifies principles on which and manner in which it be determined. Okay. We go to 300, which says protection for certain rights, provision, pensions. Executive authority of federation or a province shall not be exercised or save on an order by Governor General or Governor, as case may be, in exercise of his individual judgment so as to derogate from any grant or confirmation of title or to land or of any right or privileges in respect of land or land revenue being a grant or confirmation made before first day of January. All right. So 301, this is section 18. So 301 says section 18 of East India Company Act 1718 and section 12 of East India Act 1797 being obsolete enactments curtailing savings or native land are hereby repealed. So 1780 and 17 East India Company 1780 is repealed. So in 1780 we got repeal of this East India Company. Since 302 High Commissioner, there shall be High Commissioner for India in United Kingdom who shall be appointed and whose salary and conditions of service shall be prescribed by Governor General exercising his individual judgment. High Commissioner shall perform on behalf of Federation such functions in connection with business of Federation and in particular in relation to making of contacts as Governor General may from time to time direct. So we'll move further. High Commissioner may with approval of Governor General and on such terms as may be agreed undertake to perform on behalf of province, federal states or on behalf of Burma functions similar to those which performs on behalf of Federation. For instance, the Sheriff in Calcutta, leave that all will under this Secretary of Staff of Governor General, or Governor General, Secretary of Staff. This is Resolution 7. This is all of certain disqualification on occasion of first election to legislature. First election to legislature. For purpose of first election to persons who serve as members of federal legislature and of provincial legislatures, no person shall be subject to any disqualification by reason only of fact that he holds an office of profit as a non-official member of Executive Council of Governor General of Governors, and an office which is not a whole timing. Uh, 308 procedure as respect. 308 procedure as a proposal to amend certain provision in Act, Order and Council, leave all that. Nothing important in this. We have to share with you only important aspects of all. Leave all. Orders in Council. Orders in Council 309(1) says, any power conferred by this Act on His Majesty in Council, any power conferred by this Act on His Majesty in Council shall be exercisable only by order in Council and subject as hereinafter provided. Secretary of State shall lay before Parliament draft of any order. Secretary of State shall lay before Parliament draft of any order which it is proposed to be recommended His Majesty to make in Council under any provision of this Act, and no further proceedings shall be taken in relation thereto except in pursuance of an address presented to His Majesty by both Houses of Parliament, praying that order may be made either in form of draft or with such amendments as may have been agreed to by resolutions of both Houses. Provided that if at any time when Parliament is dissolved or prorogued, and both Houses of Parliament are adjourned for more than 40 days, Secretary of State is of opinion that on account of urgency in order in Council should be made under this Act forthwith. It shall not be necessary for draft of order to be laid before Parliament, but order shall also cease to have effect at expiration of 28 days from date on which Commons House first sits after 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 making order unless within that period resolution approving making of order are passed by both Houses of Parliament. Subject to any express provision of this Act, His Majesty in Council by its subsequent order made in accordance with provision of proceedings, subsection, revoke or vary all the Alright, yes. So order in council something else. No, it also links to institution of engineers royal charter. It's a very important part. 303, 309 in this 1935 Act. This again I read. Any power confirmed by this Act on His Majesty in Council shall be exercisable only by order in Council and subject as hereinafter provided. Secretary of State shall lay before Parliament draft of any order which is proposed to recommend His Majesty to make in Council under any provision of this Act, and no further proceedings shall be taken in relation thereto accept in pursuance of an address presented to His Majesty by both Houses of Parliament praying that order may be made either in parliament, praying that order may be made either in form of draft or with such amendments as may be have been by that. That's right. So this order in council 309 was all right. Uh, and subject to any express provision of this Act, the Student Council may by a subsequent order made in connection with provisions of proceedings subsection revoke or vary any order previously made on council. Then nothing. This section applies to any order of His Majesty in council made in connection with any appeal to His Majesty in council or to any order. Okay, right. Then 310 power of His Majesty in council through all difficulties. Okay. Then we go further. 311 interpretation. 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 In this act, this is Article 311, this is Section 311. In this act, and unless context otherwise requires, in any other act, following expressions have meanings hereby respectively assigned to them. That is to say, British India means all territories for time being comprised within governors' provinces and chief commissioners' provinces. India means British India together with all territories of any Indian ruler under suzerainty, 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 suzerainty of His Majesty, all territories under suzerainty of such an Indian ruler, tribunal areas, and any other territories which His Majesty in council may from time to time, after ascertaining views of federal government and federal legislatures, declare to be part of India. Burma includes subject to exercise by His Majesty of any power vested in him with respect to alteration of boundaries thereof. All territories which were immediately before commencement of Part 3 of this Act comprise in India. Right. Burma. British Burma. What is British Burma? Once again, Burma says something more, I think, in this, which says includes subject to exercise by His Majesty of any powers vested in with respect to alteration of boundaries thereof all territories which were immediately before commencement of this Part 3 of this Act, that comprise in India, being territories lying to the east of Bengal, the state of Manipur, Assam, and any tribal areas connected with Assam. And British Burma means so much of Burma as belongs to His Majesty. Tribal areas means areas along and frontiers of India or of Balochistan which are not part of British India. Which are not part of British India means what? This is means area along with frontiers of India, so Balochistan which are not part of British India or Burma or of any India state or of any foreign state. Indian state includes any territory whether described as state, an estate or an jagir or Tribal areas means areas along of British India or Balochistan which are not part of British India or Burma. Okay. Indian state includes any territory, whether described as a state or an estate or jagir or otherwise belonging to under suzerainty of ruler who is under suzerainty of His Majesty and not being part of British India. Ruler in relation to state means prince chief. The prince, chief, or other person recognized by His Majesty as the ruler of the state. In this act, unless context otherwise requires following expression have in this act, unless context otherwise requires following expressions have meaning hereby respectively assigned to them. Okay. So, okay, Chief Justice, all right, the corporate tax. Corresponding province and depth and existing Indian law. Existing Indian law means any law, ordinance, order, bylaw, rule, or regulation passed or made before commencement of Part 3 of this Act by any legislature, authority, or person in any territory for the time being. Okay. For Part 3 of this Act, the decision for the person is for time being comprised in British India, being a legislature authority, a person having power to make such a law, ordinance, order, bylaw, rule, or regulation. Goods includes all materials and guarantee includes any obligation, the High Court, okay, local government, and pension, and then pleader, then the Provincial Act, provincial law, public notification, okay, as a project, and provisional law means subject to provisions of this section, an act passed or laid or law made by provincial legislature established under this act. Public notification means a notification in Gazette of India or as case may be official gazette of a province. Security includes stock, taxation, railways, federal railways, Indian state railways, minor railways, unit means a governance province, a governance province chief, commissioner's province like that. And paragraph of section 18 of the election is I go. Okay, petition the to Parliament to with now expectations. Transitional provision 312 provision of this part of this act shall apply with respect to period elapsing between commencement of part 3 of this act and establishment of federation. Then 313 is executive government subject to provisions of this act for time being enforced such executive authority as is ever mentioned shall be exercised by on behalf of a High Majesty. High Majesty, Governor General in Council, I directly or through office subordinate to him, but nothing in this section shall prevent Indian legislature from conferring functions upon subordinates. Was all right. We'll go next one. Then it is I think this. Okay. We'll see what to do with this. Because then we can say sometimes problematic, for me to find that. Let's see where it goes actually. Then it is reference the principle of this act for time being enforced on general federal government. Then, there is anything special, article special. I'll see nothing in the section 3. 3 for control of Secretary of State, leave behind this. We don't need sterling loans. We don't need power conferred by provision. This legislature, what's that? Power conferred by provisions of this Act for time being enforced on federal legislature shall be exercisable by Indian legislature and accordingly references in those provisions to federal legislature and federal laws be construed as reference to Indian legislature and laws of Indian legislature and reference to those provisions of federal laws shall be considered as references to taxes imposed by laws of Indian legislature. 317 continues certain provisions according to the Act. Okay, leave that. Then, of course, then this I saw Elected General Council. Right. 390 and then commencement repeals. What commencement repeal says? Commencement of the bill says commencement repeal. Part 2 of this act shall come into force on such date His Majesty may appoint. All right, come under this act shall subject to so. Schedules, and there are schedules. General qualification of membership. A person shall not be qualified to be chosen as a representative of British India to fill a seat in federal legislature unless a British subject or ruler or a subject of an Indian state which has acceded to federation. As in case of seat, the Council of States are not less than 30 years of age, and in case of seat in Federal Assembly, not less than 25 years of age, possess such, if any, of all other qualifications specified in or prescribed under part of this schedule as may be appropriate in his case. Council is the same explanation. I think. Federal Assembly, so this is all same, we do not worry about this. Okay, I think we've done this. All right, we'll move further on. So. So, dear friends, we have gone through thoroughly on Government of India Act 1935 just to understand how we were ruled by British. I have scanned all document and talked to you, spoken, read through required necessary paragraphs of act because all were not required, is having more than 300 sections. And our constitution our constitution of this country now, that is Constitution of India, Sab Bharat ka Samvidhan, has withdrawn from or extracted from this act that's called Government of India Act 1935, about two-thirds provisions for structure of our constitution, and remaining one-third extracted from 12 different constitutions pertinent to many countries around the world. So our constitution is a collection of languages and scripts and relevances from 13 countries. It's not one-man job, and it must have taken a lot of time to collect, to analyze, and to infill with, of course, required amendments or edited, or you can say rewrite and rewrite and rewrite and rewrite. Many writings must have been done to give shape to our current constitution, which is a hallmark, or you can say milestone, or a tool to take us to new direction, and that done in 1950. For implementation in 1949 for draft, it took 3 years minimum, maybe more, since we got independence. So I'm not saying everything is perfect, but it's more or less a dynamic document, a document that requires development, is already developed to some levels, but yet many contents could still be silent, which revolutionary answer people have to find, courts have to find, parliament has to find, and on top of that, public has to find for permanent use. No constitution is ever complete in history of whatever nation. It keeps on moving depending upon changing times, changing situations and environment of humanity. Today what we think is right, maybe tomorrow that is not right or partly right. So we have to move from here to there, and then we have to there to somewhere else, and there somewhere else. It keeps on moving like that. We have to understand this reality. Our freedom fighters and forefathers have given us something by their hard work, intelligent work, visionary work. We have to re-understand that. We have to revisit every page, every article, and try to enrich that article with standard and consistent and competent information so that it works very well. We cannot say there is a stone line on that. No, it has to change, and that is purpose of our people's parliament. That's purpose of all ours. If it's because defective, it's defective somewhere, that defect should be repaired. And that is what all about of legislature. We are making many laws in compliance with this constitution. No law can be drafted, no law can be conceived in contravention of whatever provisions are made in constitution. That is very, very important. People have to understand this, and particularly youth of this country, 40 crore youth of this country or 50 crore of youth of this country have to understand this. Once you understand our constitution, you shall find pleasure in understanding management of this country, in understanding governance of this country, in understanding philosophy of this country. Until and unless we are not clear about that, we keep ourselves in darkness, and that darkness has to go. Do not rely on political people that they will help you. They will not help you. They will help only for themselves, because they have to stay in power, which is their job, their employment. That is the most serious issue. They think that their job is governance, while we think our job is to push nation to progress, to push nation ascend on higher levels, scientific levels according to fundamental duties mandated in Article 51A of Constitution, which is very, very, very useful. And it says in brief, you have to abide by Constitution, you have to respect, honor your flag and national anthem, you have to follow sciences, you have to do everything in science and engineering, you have to develop yourself, your formula, your subjects, and apply on nation as engineering, and take this to higher levels where people develop. You have to remove, you have to eliminate. You can say, don't depend upon religion. Religion is not defined there, but you are free to practice whatever you practice. You have to think on those ideals, on those visions which your forefathers, fighters lived their lives for. You have this, what they wanted for you. You have to contemplate that, to bring that vision to your mind and reinvent it, how you should move forward. That's ideals. You cannot define those ideals. Those are ideals of foundations for ourselves. Why we got liberation? We required this, or we were forced to get that, or we was abused by our society. Abused. It was abused for years, for centuries, and that's the reason we got to door of liberation. And that door which united for the seven, that door has to be fully penetrated for correction, repairs, and still unable to correctly repair in totality. That's where problems are arising. And problems are arising, we have to chart out solutions from those problems. And we cannot do anything. And that's why I'm saying we have to come out of sleep. We should not sleep. We have to come out to think about all this. We are not to think of religion or first of all think for nation as a whole, society as a whole. Everybody should have food, for clothing, for shelter. Everybody should be educated. There should be industrialization. There should be agriculture. Everything should be there. Economic has to go up. We have to rise up and rise up. Education, health, agriculture, and personal life, uplift, removal of poverty, removal of illness, removal of sickness, removal of paradox, orthodoxism, all are required to happen. And it's we people of this country have to do that. Nobody else will come from overseas or from other planets to help us. It's we only that have to do this. This is very important one. That was only reason I wanted to tell and know and advise and project India Act, India Government of India Act 1935, and then will discuss also, which I have already done, India independence in 1947. Once we understand all this, then we can understand very well what is value of current constitution and various laws, and what we are doing in parliament. Like fools or like intelligence, we have to analyze that position, because that is very important. हमेशा अंधेरे में रहने से काम नहीं चलता, अंधेरे को समझ के लाइट में आना पड़ता है, नहीं तो अंधेरे में क्या क्या गलतियां हम समझ नहीं पाएंगे, अंधेरे में क्या क्या राज छुपे हम समझ नहीं पाएंगे। हम पर राज किया गया बहुत सालों से, सेंचुरीज से, डिकेड से बहुत राज किया गया लोगों ने। अंग्रेजों ने किया, उससे पहले मुगलों ने किया, उससे पहले औरों ने किया, और हम गुलामी की जिंदगी हजारों साल से जी रहे, अब भी जी रहे। सच पूछो तो गारे गोरे चले गए, काले आ गए, पब्लिक वहीं की वहीं है। किसी को क्या मिला है पब्लिक भी नहीं जानती। हमें उस चीज को ही तो समझना है। हम जब तक वो चीज समझेंगे नहीं, हमें कुछ समझ नहीं आएगा। और यही कारण था कि मैं चाहता था देखना कि पहले हमारे पास कौन सा संविधान या भारत का कानून लागू होता था, जिसको हम कहते हैं ये भारत का एक्ट, भारत सरकार का एक्ट, भारत सरकार का एक्ट 1935, जो हमें बता रहा है, जो आज एक हिस्सा भी है हमारे संविधान का, उससे लिया गया। एक तरह का वो संविधान था उस समय, उसको भारत का एक्ट कहा जाता था। भारत सरकार एक्ट कहा जाता था, अधिनियम कहा जाता था। इतने 300 से ज्यादा पेज, 400 से ज्यादा पेज का डॉक्यूमेंट, उसमें सब कुछ करीब करीब वही लिखा है जो हमारे संविधान में उसको अमेंड किया गया होगा, सुधारा गया होगा और बाकी देशों से लिए गए थे। उन सबको माला मिलो के हमको एक संविधान का एक दस्तावेज मिला 1950 में, और अभी चल रहा है। उसी दस्तावेज को, मैं ये नहीं कहता कि सब कुछ सही होगा उसमें, उसको सुधारा जा सकता है, सुधारा भी गया है। उसमें समझा गया है कि हमारी जिंदगी से कितना मेल खाता है, हमें कितना आगे का रास्ता दिखाता है। हमें हेल्थ सेक्टर में, पढ़ाई एजुकेशन के सेक्टर में, और रोटी कपड़े मकान के सेक्टर में, और इकोनॉमी अर्थव्यवस्था के सेक्टर में, आगे जाने के सेक्टर में, विकास के सेक्टर में हम कितना आगे जा सकेंगे या नहीं जा सकेंगे। हर आदमी को आगे निकलना है, हर व्यक्ति को, नागरिक को आगे निकलना है। हम नागरिकता को कितनी वैल्यू देते हैं अपने देश में, हमें राजनीति वालों को कितनी वैल्यू देनी चाहिए, हमें वैज्ञानिकों को, डॉक्टर को, दूसरों को कितनी वैल्यू देनी चाहिए, ये सब बातें समझने की होती हैं। जब तक हम समझेंगे नहीं, हम खाली ये नहीं कह सकते हमें नौकरी चाहिए, नौकरी हो गई हमारा काम खत्म हो गया, पढ़ गए लिख गए। नौकरी एक अलग चीज है, लेकिन सवाल ये उठता है कि हमें देश को किधर लेके जाना है। नौकरी तो आप विश्व में कहीं भी जाके कर सकते हैं, लेकिन देश आपको कहीं नहीं मिलेगा। अपना देश अपना होता है, दूसरे का देश दूसरे का होता है। लोग भागते हैं, जहाँ जहाँ गल्फ में जाते हैं, इंग्लैंड में, अमेरिका में, सब जगह जाते हैं जॉब करने के लिए, लेकिन जो देश अपना देता है वो दूसरे का नहीं देता है, और दूसरे का छीन लेता है। यही हो रहा है। हमें खैर उस बात से अब क्या लेना देना है, हमें देश को संभालना है। हमें देखना है कि हम गलत हाथों में देश का सत्ता ना जाए, गलत हाथों में देश की राजनीति जाए, गलत हाथों में सरकार ना आए। हमें ऐसे हाथ चाहिए, ऐसे माइंड चाहिए जो देश की सोचें, अपनी नहीं, जो लूट मार ना करके देश की सेवा करें। हालांकि ये बातें कहने में अच्छी लगती हैं, वास्तविकता से बहुत दूर होती हैं, लेकिन फिर भी जितना कम से कम नुकसान करा सकें, जितना देश को बचा सकें, क्योंकि देश हमें मुफ्त में नहीं मिला। लाखों लोगों ने यहाँ पे सेक्रीफाइस की, बलिदान की, तब जाके हम तो स्वतंत्रता प्राप्त हुई होगी। ये एक वास्तविकता है जो हम भूल नहीं सकते, मना नहीं कर सकते इस बात को। और हमें आगे सोचना होगा ध्यान से कि आज जो चल रहा है, आज का युवा जाग रहा है, आज की जनता जाग रही है, महिलाएं जाग रही हैं और पुरुष जाग रहे हैं, बहुत अच्छी बात है। और वो लोग जाग रहे हैं जो बहुत पैसे वाले नहीं है, बहुत ऊंचे पे नहीं, और छोटे लोग, बड़े लोग, मिडिल लोग सब जाग रहे हैं। इससे मुझे अच्छा लगता है कहने के लिए कि नागरिक जाग रहा है, सिटीजन जाग रहा है। सोने दो उनको, पहले सोते थे, हम कहते थे उठते नहीं है, अब उठे तो सही। अरे अब सो मत जाना दोबारा से। इन प्रॉब्लम समस्याओं को जब तक सॉल्व नहीं कर लेते, भूल जाओ ये राजनीति वाले आपके लिए कुछ करेंगे। कोई राजनीति वाला आपके लिए नहीं करेगा, आपको खुद राजनीति बनना पड़ेगा, आपको खुद अपने को लीड करना पड़ेगा, अपने नेता खुद गिरी करनी पड़ेगी, आवाज उठानी पड़ेगी, शोर मचाना पड़ेगा, संविधान को समझना पड़ेगा। जब तक आप संविधान को समझोगे नहीं, अपनी वैल्यू नहीं समझ सकते, अपने राइट्स नहीं समझ सकते, खाली शोर मचाने से कुछ नहीं होता। संविधान को ध्यान से पढ़ो, बैठ के समझोगे आपके अधिकार क्या हो सकते हैं, और ये लोग आपको क्या मांगते हैं, ये क्या समझते हैं, ये आपको कितनी वैल्यू देते हैं। ये जब तक यह कह सकते कि अपनी नागरिकता का प्रमाण दो, इसका मतलब आपको तो अपराधी मानते हैं, आपको तो घुसपैठी मानते हैं। जिनको आपने सीट पे बिठाया, आज वही आपका ग्रहमान पकड़ के कह रहे हैं बता कि आप कौन हो। अरे तुम सीट पे बैठे हो, तुम सीट से नीचे उतर जाओ, हम बता देंगे आप कौन हो। हमने सीट पे बिठाया और हमसे सवाल कर रहे हो, आप भी सीट पे गलत बैठे हो। अगर मैं नागरिक नहीं, देश के ये लोग नागरिक नहीं, तो आप भी नेता MP कैसे बन गए। आप सीट छोड़ो, प्राइम मिनिस्टर सीट छोड़ो, फिर प्रेसिडेंट सीट छोड़ो, नीचे आओ और पुलिस वालों अपने ड्यूटी करो। आप किसी मिनिस्टर के अंडर नहीं आते, आप पब्लिक के अंदर आते हैं, आप संविधान के अंदर आते हैं, आप पुलिस के नियमों के अंदर आते हैं। आप गलत इंस्ट्रक्शन लेना छोड़ दो, क्योंकि आप इतने भी ज्यादा नहीं हो कि अगर पब्लिक भड़क गई आपके ऊपर, चला लेना गोलियां, चला लेना बंदूक, कितनी जेलें भरोगे पता लग जाएगा आपको। पब्लिक जब भड़कती है तो बड़े से बड़ी सत्ता नीचे आ जाती है, याद रख लेना। ये वही पब्लिक है जिसने अंग्रेजों को भगाया है। आप तो छोटे छोटे बच्चे हो, आप में से कोई था भी नहीं जब देश आजाद हुआ था, जब स्वतंत्रता का संग्राम हुआ था। आप में से आज की तारीख में कोई पुलिस वाला नहीं होगा जो उस टाइम था, और ना ही कोई फौज वाला होगा जो उस टाइम था। इसलिए जनता की सेवा करना सीखो। गोलियां चलाना बहुत आसान है, आंखें फोड़ना बहुत आसान है, ये कहना कि स्टूडेंट आतंकवादी है बहुत आसान है। स्टूडेंट के आतंकवादी हैं, स्टूडेंट के आतंकवाद तलवारें लेके, बंदूक लेके कॉलेज जाते हैं पढ़ने के लिए। बड़ा दुख होता है ये बात सुन के। खैर अभी मैं ज्यादा नहीं बोलूंगा, बहुत देर हो गई है, बाद में बात करेंगे। लेकिन जागते रहना, सोना मत। दोबारा मैं फिर कह रहा हूं, ये सरकार चाहती है आप सो जाएं, ये सत्ताधारी चाहते हैं आप सो जाएं और ये अपनी मनमानी करें। ये देश को बेच रहे हैं, कंपनियों को बेच रहे हैं, सब कुछ खत्म कर रहे हैं, लोगों का पैसा खाना चाहते हैं, टैक्स पे टैक्स लगाना चाहते हैं, सेवा नहीं करना चाहते, बातें करना चाहते हैं। इनसे बातें करा लो, कुछ भी करा लो, झूठ बुलवा लो, सच बुलवा लो, सब बोल देंगे संविधान की कसम गई भाड़ में, संविधान को बस नमस्ते करना है, तो माथा टेकना है और फेंक देना है, शपथ ले ली, बात खत्म, मेरा संविधान अपना है। हमें आपका संविधान नहीं चाहिए, हमें देश का संविधान चाहिए। हम उसको अपना धर्म मानते हैं, हमारा पर्सनल धर्म बाद में है, पहले संविधान धर्म है। हमने संविधान की, सबने शपथ ली है। हम कोई भी कागज साइन करते हैं तो संविधान की शपथ लेते हैं, वोटर आइडेंटिटी कार्ड के लिए शपथ लेते हैं, हम किसी भी चीज के लिए, पासपोर्ट के लिए शपथ लेते हैं, हर जगह के लिए शपथ ली जाती है। हमने सबने संविधान की शपथ ली है। आप हमसे नहीं कह सकते कि ये संविधान नहीं चलेगा, हम आपको नहीं चलने देंगे, संविधान चलेगा। अपने मन से गलतफहमी निकाल दो, भारत संविधान संविधान है। इसलिए मैं फिर कहता हूं, अपनी औकात में रहना। संविधान किसी की शक्ति नहीं है कि 130 करोड़ जनता के सामने, जिसमें से 20 करोड़ आपके चमचे हो सकते हैं, फिर भी 100 करोड़ बैठे हैं, 100 करोड़ आपको संविधान पे हाथ नहीं लगाने देंगे। जय भारत कहता हूं इसी बात पे, जय भारत, जय संविधान, नमस्कार, गुड डे।